Pardon to make a mention.
Item 3, format 2. Page 2, item 5 to 13. Page 3, item 14 to 20. Page 4, item 21. Page 4, item 21. Page 5, 22 and 23.
Okay, let it come tomorrow. 16.
Here on the court.
Yes, so much. No, sir, I'm not in power, I think. Yasha. Kundu.
Cause list or your file?
Yes, so much.
Are you checking the cause list or your file before making a mention?
Yes, sir.
Where's your list? Where is your list?
Don't be so casual in future.
And if you don't remember if you've signed the wakalatnama, please look at the cause list. Do you know what the cause list is? If your name is there, that means you hold power in the case. We are looking at the cause list and telling you. And you're such a young lawyer, and if you're careless and so casual, how can that be?
Page 8, item 24 and 25. Page 9, item 26 to 29. Page 12, item 30 to 35.
Item
27, madam. Can be taken up next week.
where?
27.
Madam, conducting council not here today.
No, no, all right. Item 27. What is your prayer? I could not follow you.
Or adjournment.
For adjournment, seeking adjournment, madam.
We can't hear you.
My lord, item 27.
Ah.
I'm seeking adjournment. If you can, request can be taken up next week.
All right.
Madam.
Well,
28.
you are Mr.
A Panda, madam. My name is there.
The request of Mr. Pandal and council agreeing for the petitioner, let the matter be listed on 27th of July 2023.
28.
28th of July. 28th of July 2023. Have you informed the council for the opposite parties?
My lord, I will inform, madam. I will inform, madam.
But this is not the practice of this court. You
I
have to
know.
first inform because they might have a say. All right.
Page 12, item 30 to 35. Page 13, item 36 to 39. Page 14, item 40 to 45. Page 15, item 46 to 52. Page 16, item 53 and 54.
I may be pardoned to make a mention.
Yes.
I'm in virtual mode.
Yes.
But one matter listed on 24/6, matter relating to Konark Temple photographers, my lord. Your lordship matter could not be reached on that day. On the last week also, I made a mention before your lordship. Your lordship is pleased to allow my mention, and still matter is not coming. My contempt application is urgent, my lord, that CONTC number 576 of 23. That may be taken.
Public interest litigation.
No, my lord. It's a matter. It's a writ appeal, my lord. Learned single judge directed without.
Tomorrow. Can you just share us with you the writ appeal number?
Lord, my associate is there, my lord, along with a memo. He will
Give a memo. Just list the matter tomorrow.
oblige, lord.
All right,
Deeply.
Mr. Das. That will be taken up tomorrow.
Deeply obliged.
But there is no writ appeal. It is a contempt case relating to the writ appeal.
Writ appeal arising out of 81 of 2022.
But the
WA
memo is of the contempt.
My lord, memo is of contempt
Written.
arising out of my associate will write it. 81 of 22.
We are not
WA
taking time matters. So if you are interested in WA 81 of 2020,
yes, ma'am.
2022, that can be taken as.
I will make it mention in the memo. It's
All right,
Fine.
just
81 of 22.
just correct the memo.
Yes.
Yes.
Obliged.
I may pardon to make a mention, my lord.
Yes.
Say, matter honorable single judge are directed to declare one subcaste in the sub main caste. So in that case, a contempt has been filed.
You have filed the appeal.
Yes, ma'am. That fresh.
Tomorrow I will
Yes,
take up the matter.
Only when contempt is filed, you're making a mention. Why don't you mention it before?
WA.
List tomorrow. Call. At the request of Mr. B.K. Patnaik, learned counsel appearing for the petition. When is the date? Next date in other cases?
24th July.
The matter will be listed on 24th of July, 24th July 2023, when the analogous matters are listed. Mr. M.K. Kuntial, an international government advocate, appears for the opposite party state.
Item 7.
Item 7, my lord, similar to item 6, my lord.
The request of Mr. K. Swine,
Yes,
and counsel appearing for the petitioner, same order, huh? Just copy it, all right.
In both the cases, notice it to go on a first time.
Notice has not been issued, my lord, in this matter.
That day.
So that we will consider.
No
on that
opposite part, no private opposite parties.
State.
No, only state, my lord.
day. On that day, we will consider on merit, comes
Yes.
prepared.
Yes, ma'am.
Item 8.
Item 5.
Huh?
Item 5. One
No,
person.
he let him wait.
Item 5, we are just passed over, Mr. Counsel. Just wait for some time.
Item 8.
I'm appealing along.
Sorry, Mr. Have you just checked up the case? This petition, this appeal. Why is this infirmity in the judgment of the learned civil judge? Straight come to the order. Someone was just, you are trying to, this case is very simple. That you want to add some periods you have served. This is the case, I think.
Yes, ma'am.
And you are terminated because you are not eligible to be appointed. How that period can be added to that? Secondly, when you are also brought to the regular establishment, the total period is 3 years and odd.
No, 9 years, 4 months.
Come to that because this is the observation. You come to that how this calculation has been made.
Let me place the
Yes.
the dead chart.
Yes, date charge is already there with us.
Is it there?
We have already a date chart.
Yes, ma'am. Let's look at that dead chart.
Yes.
26th March 1980.
Yes.
The appellant was initially appointed as a lecturer in political science in college in question. 1781, the service of the applicant was terminated as he had secured less than 54 marks in post-graduation.
Yes.
81, the appellant improved her performance. She secured 54.4% marks and thereby acquired the eligibility qualification to hold the post.
Yes.
It was assured by the management to take her back after obtaining the eligibility qualification. 92, the appellant application bearing number such and such was disposed of by this honorable court with a direction to dispose of the representation of the petitioner. 18/9/92.
Yes.
The appellant submitted a representation pursuant to the said representation. The Director of Higher Education Department, Odisha, directed the college and constitute to consider the case of the applicant. 16/3/93. Next page, my lord.
Yes.
The governing body of the college took decision to appoint the appellant as lecturer with effect from 1/4/93.
Yes.
However, no appointment was given. Let's look at my lord. Even 16/3/93, this honorable court directed, even a decision was rendered by the director, but no appointment was given. It was given on 30th March 1994.
Yes.
The appellant once again approached this honorable court in OJC number such and this honorable court was pleased to allow the petitioner and to permit the petitioner to join as lecturer. Then, my lord, 28/4/94, allowed to join in service. 31st/8/2003, the appellant retired from service on attaining the age of superannuation and thereby completed 9 years and 4 months of service. Since no pension was given to the appellant once again approached this honorable court that was dismissed on the account of not completed 10 years. Then, I mean, receive attention to
Just to
facts.
come to the serial 10. That is the whole prayer. That is, I am just
Yes,
pressing.
ma'am. Yes, ma'am. I am admitting that. My humble submission is, let's say look at rule 7. Of the Odisha Aided Educational Institution Employees Retirement Benefit Rules 1981.
Yes, you read a little slowly. Yes.
Then, my lord,
That is also page 62 of writ appeal. That rule is there.
All right.
62. Rule 7, ma'am. Page 63. In case of an employee retiring on or after the first day of April 82, any period of break in service caused on account of retrenchment or similar other reasons which is beyond the control of the employee concerned will not be treated as interruption involving forfeiture of past services. That's why I was retrenched, my lord. I was terminated. A, B, my lord. My second submission would be
No, just you have referred which provision?
Rule 7, my lord. Page 63. Up the writ appeal, my lord.
This. Just 1 minute, please.
Bottom part, my lord, page 63. Rule 7 of the writ appeal.
Rule 7, only Rule 7.
Page 63, ma'am.
In case of an employee returning on or after the 1982,
In case of an employee retiring on or after the first day of April 82, any period of break in service cause an account of retrenchment or similar other reasons which is beyond the control of the employee concerned will not be treated as an interruption involving forfeiture of past services.
so
This is my humble submission as since I was terminated or retrenched, so this period should be counted. This is one submission. Second submission is I was admittedly directed by the director. Let's say look at the debt chart on 18/9/92 to allow me to join. But I was allowed to join on 28/4/94.
that cannot be because you are
So-
admitted. No, you are admitted that was the date of your appointment.
Date of appointment was 94, though directed by the court as well as the
That can, be
director.
that can be subject matter of the contempt if there was any violation.
No, I'm not on the content to
Yeah.
treat the period because I was allowed by the director as well as by this honorable court
But the authority has issued the appointment letter.
in 94.
Then that's all.
Then I may indulge your lordship attention, the last submission of mine.
Yes.
Lordship kindly turn to rule to avoid all the everything, my lord. Rule 15 of the said rule. Then I will cite authority judgments of the recent judges of this honorable court.
Rule
Rule,
15.
my lord, 15. Lordship kindly again, my lord, turn to page 69. Rule 15, my lord.
Page 69.
Rule 15, my lord. I'm sorry, that is not there, my lord, in the writ appeal.
Give the book.
This is Odisha Aided Education Institution Employees Retirement Benefit Rules, 1981.
Okay. Aided colleges. Odisha aided colleges and junior colleges.
Odisha Aided Education Institutions Employees Retirement Benefit Rules, 1981. May I assist your lordship, my lord?
Yes.
Page 891.
This book.
If this is the book my lordship is holding, that is 891, page 891.
Yes. You are referring to which rule?
Rule 15, my lord.
Eight, 9, 1.
Rule 15, relaxation power vested with the government.
Who that?
Rule 15.
Yes.
One rule doesn't go to 15, right?
Page, Mr. Khuntia, what is the page? It is not telling you.
There's some orders there.
This is the different rules of 1981.
81.
Mr.
It starts from page 880. Your lordship can find it from that my learned friend is referring at page 888, 888, my lord.
888. All right. Yes. So this point was raised before the learned single judge?
That's
whether this point was taken before the learned single judge.
now, my lord, when I argued a matter before this division bench on the self-same or more or less the same issues, like we could not get the pension because not completed 10 years.
Yes.
The lordship have taken observation on a hardship, on due hardship, and given the judgment that in such a circumstances, minimum pension should be granted to a lady who has completed 9 years and is a divorcee, also 81 years old.
This relaxation can be granted by the
By the
court.
government. That's the court has given a direction to the government. Let's take a look at the judgment.
Court can
of the
only give
division
the
bench.
direction to the government to
And
consider.
they have taken note of what
Whether
is
the
the
court can
undue
take that
hardship. Exhaustively from paragraph 12 onwards, 10 onwards, 12 onwards.
Yes.
So lastly, they directed the authority to consider in view of the power vested with the government, para 18. Pensioner to receive from the foregoing discussion, we are of the view that rule 47(2)(b) of the rules entitled the pensioner to receive pension if he works for 10 years be relaxed. In the present practical circumstances case, where the past experience of vision has sustained pollution, that should be added to fill up the gap 45 days, a short period required to get money. We therefore direct the state government to place the matter before His Excellency Governor. But this is the matter relating to public prosecutors, not completed 10 years, therefore could not get the pension. As per rule 144, this is the paramaterial to rule 15 of the present rules. We hope and trust that the concerned authority would consider the undue hardship for compliance of
So,
the.
Mr. Mishra, this is a direction to consider by the government.
Yes,
That is
let
what I am
them
pointing at
exercise
you.
the
There is
power
no
under rule
direction.
15.
Court cannot issue any directions to just allow you under this provision because it is a discretion of the state.
True, my lord. But the
Your
power has,
hardship will be considered by the state, not by us, because it is their rule, whether they will relax it or not.
they have not exercised that power. Therefore, I'm praying for lordship, let
That is
them
my
exercise,
question was
examine
there
and
first,
exercise the
whether
power.
have you raised this issue in the writ petition to know their opinion? Number two, whether have you filed such application admitting that you are short of it? Because you cannot on the two boards at the same time. You are the first is that period you are entitled to get, so it will make you the deficit,
That's
the
true.
10 years.
8 months.
That you have to decide yourself, which is your claim, on the basis of which ground you try to proceed. That if you forego that, then only the second part will come, 15. Of course, we can now also take up this point. There is no issue because it is a continuation of the writ petition. So you have to either abandon that without complicating the issue, because if you say that because according to your grounds that you have taken in the memorandum of appeal, that is the only ground that 81 up to 81, whatever you served before termination, that period should be added. According to us, that period cannot be added even under the provision that you have shown to us. For the
Rule
same
7.
reason, she was incompetent to hold that post. And that was the reason of the termination, not for any the difficulty of the employee which has been provided. It just as opposite. It was the ineligibility of the person that she was terminated, and this period cannot be treated because that will be the perpetration of the illegality. No court can do that under Article 14 of the Constitution. So that point, if you leave, we are agreeable that we can direct the state to, you will make a representation and direct the state to consider your hardship, because the shortage of period is about 8 months.
8 months.
If they can relax that, you can get at the minimum pension for
That's
that can be true because it is the
He's
discussion
81 now.
we are passing you take
He's
it.
81.
Otherwise, they have no
Lady,
case.
81.
Yes.
They can file a representation. Heard Mr. KP Mistral and his senior counsel. You are Mr. Roth.
He's Mr. Rath.
All right. Instructed by Mr. D.N. Roth and counsel for appellant. We have also heard Mr. M.K. Kuntia, an additional government advocate, appearing for the respondents opposite respondent state by means of the intercourt appeal. Judgment dated, order dated 31/8/20. There is a 2010 order.
Yes, ma'am.
Are you sure? Just check up.
Deal has been condoned.
Now it's all right. We are, order dated 31/8/2010, delivered in WPC number 19149 of 2008 by the learned single judge has been challenged. Mr. Mishra, learned senior counsel, has based his argument on two primary grounds, is that for not including the period the petitioner, the appellant served from 26/3/1980 to 1/8/1981 by not adding the period with the qualifying service of the appellant. That single judge is committed with serious error. Stop. So, however, Mr. also drawn our attention that even though this court in OG, even though by the order passed in OGC number 6323 of 1993, the management was directed to appoint the petitioner as lecturer and allow her to join the post. Finally, the management allowed the appellant to join in the service as lecturer on 28/4/1994. Stop. It is an admitted position that against the same decision of the management, the appellant did not raise any objection or did not challenge the said action of the management till filing of the the present writ petition being till filing of the writ petition being WPC number 19149 of 2008. Stop. Though not very robustly, but Mr. submitted that from the date of the decision taken by the governing body of the college within the management, the petitioner service should be counted, meaning the petitioner service should be counted from 1/4/1993. Stop. An additional plea has been raised, Mr. Mistral and his senior counsel at this writ appellate stage, that since the appellant will face serious hardship if she is not provided with pension, even if minimum pension, the government may be directed to relax by condoning the shortage in getting the pension in exercise of their power as provided under Rule 15 of the Orissa Aided Educational Institutions Employees Retirement Benefit Rules 1981. So for purpose of reference, we reproduced Rule 15 here under colon 15 stop, where the government is satisfied that the operation of any of the provisions of these rules causes under hardship in any particular case, it may by order dispense with or relax the requirements of the said provisions to such extent and subject to such condition as it may consider necessary for dealing with the case in just and equitable manner. Stop. Mr. M.K. Puntia, learned counsel appearing for the respondent state has submitted that the Rule 15 doesn't have any application for relaxation the cases of this nature. Stop. According to him, that the petitioner claim for the granting the pension under the said rules is not supported by, is not tenable in as much as the appellant has not petition. Appellant has only served 9 years, 4 months in the service. Stop. Minimum service as required for getting pension is 10 years. Service to get the pro rata pension is 10 years. Stop. Having appreciated the submission of the counsel for the parties, we are of the view that the petitioner cannot claim for date of appointment as 1/4/1993, inasmuch as there was no formal appointment of the petitioner before 28/4/1994. Stop. That apart, the period from 26/3/1980 to 1/8/1981 cannot be treated as a part of the qualifying service for two reasons. Number one, this is not the part of the continuous service. And number two, the petitioner was terminated for lacking the basic qualification to hold the post. In the subsequent judgment, that aspect of the matter has been discussed and it has been held that the petitioner is not entitled to get any benefit of the said period. Therefore, this court is not inclined to reopen the issue for any purpose, as on those findings are based on sound reasons. However, that we think that the petitioner may be allowed to file a representation to the appropriate authority of the government for having the relaxation under Rule 15 of the said rules. Stop. Such representation shall be made by the petitioner within 30 days from today. Stop. The state government shall examine the representation of the petitioner in order to explore whether the relaxation can be granted to the petitioner, so the petitioner can have the minimum pro rata pension. Stop. In terms of the above, this appeal stands disposed of. A copy of this order be provided to Mr. Anthil, an additional government advocate.
Item 12.
Item 12, my lord, I have already filed the limitation petition. So for the defects are concerned, your lordship may grant some time, I will remove it. I have already filed the limitation petition, my lord.
Yes.
So for the defects are concerned, I will remove it within a week, my lord.
Where the matter will listed on 28th July 2023. You are Mr. Mahapatra.
Yes, my lord.
At the request of Mr. S.N. Mahapatra and counsel appearing to the appellant. Mr. Mahapatra has undertaken that the defects as identified with the registry shall be removed by the next stage. Okay, next.
Item 13.
13,
Yes.
Your Lordship, on behalf of Dr. Lenka, not pressed, Your Lordship.
It will be not pressed.
Yes, Your Lordship.
You are appearing on behalf of Dr. Lanka. Are you on record?
Oh, no, Your Lordship.
What is your good name?
Lakshmikant Tripathi.
Have you filed any memorandum?
I filed it today, Your Lordship.
File
Your Lordship.
already. Otherwise, you will not sign the order.
Your Lordship.
Mr. Lokhikanta,
Lakshmikant Tripathi.
Lakshmikant Tripathi,
Yes,
L.K. Tripathi.
Yes, Your Lordship.
Okay, at the request, Mr. L.K. Tripathi, Learned Counsel, appearing on instruction of Dr. J.K. Lenka, Learned Counsel, appearing for the appellant, has submitted that on instruction of the appellant, they have filed a memorandum seeking leave of this court for not pressing this appeal. So memorandum is taking on record.
Yes.
We do not find any impediment to allow the petitioner to not press the appeal. Accordingly, this appeal stands dismissed as not pressed.
Oblige, your lordship.
You file this
Yes, your
memorandum.
lordship, within
Yes.
hour.
Item 14,
Please, your lordship.
Yes, you are in item 14, Mr. Counsel.
Lordship, I am today, I'm not feeling well, lordship, because for my eye problem. Kindly
Mr.
take care of it, lordship.
You are Mr. Sahu, Debashish Sahu. You are Mr. Debashish Sahu.
Lordship, I'm Mr. Devashish Sahu.
Debashish Sahu, no? At the request of Mr. Debashish
Lordship.
Sahu, and counsel appearing to the appellant, let the matter be listed on 14th August 2023. All right.
Right.
14th of August, it will come again. Next.
item 17,
May I please, your lordship? In item 17, the defects I have removed. The two defects that remains are, my lord, the one is with regard to the fact that page 58 to 60 and 83, 87 are not legible. That is the copy of the writ petition which was served on us, where the opposite party for the honorable single judge. And that is visible, but the background is black. And that is how it was filed for this noble court. Man, that is the copy we have filed. I will humbly
We
pray.
will not engage in such interaction, Mr. Mishra, that you file a typed copy. We are granting you some time.
My lord, the one more thing I was praying, my lord, because of the urgency of the matter, where it was though filed claiming for police inaction, which should have been a CRLMP, a WPC was filed and it was entertained and order has been passed. Limitation has been shown for the reason, though the appeal was filed in time, your lordship, but the certified copy of the order was filed belatedly, and that is how technically limitation has been shown. If your lordship will kindly permit me,
Have you
then
filed the application for limitation? No?
I'll present it with your lordship's kind permission, if your lordship permits me, my lord, today for consideration.
Limitation.
My lord.
Why in the court?
I'll file it in the registry, but I'm only my anxiety is I'm praying for a short date, my lord. That
All right. When?
But that is the only
18th of July, file it. It will come on 18th of July.
my.
All right. At the request of Mr. S.K. Minstrel and its in a council, assisted by, what is your good name?
Shonali Panigrahi.
You are not on record.
She has joined.
It's a problem.
Even not a month back.
When a senior counsel appears before us, we expect that someone on record should assist him.
My lord, I'm very sorry. I'm organizing it.
All
my
right.
lord,
Let
finding
the
it
matter
little
be listed on
difficult.
18th of July 2023.
He is there, my lord.
In the
Mr. Das
meanwhile,
is there.
necessary application seeking condonation of delay may be filed by the appellant.
My
All right,
lordship, please, Mr. Das is there.
All right, assisted by Mr. S. Das. Huh? All right.
Grateful man.
item 18,
May I please, your lordship?
Yes.
49 days, 47 days are delay.
Yes. No notice has been issued as yet.
No. The other side has appeared.
My
I
lord,
have served the copies.
I'm appearing on behalf of the respondent number 1.
All right.
My lord, there is nothing. Only to harass the respondent number 1, this writ appeal has been filed.
True, because that we'll decide on when will we take up the writ appeal. But whether do you have any objection about the delay?
Delay, my lord, delay may be allowed, may be condoned with heavy cost, my lord.
Okay. What is according to you will be the heavy cost?
My lord,
47 days delay.
47 days delay, due to nothing. Your lordship may kind of a glance that ground taken in the interim application, my lord, for condonation of delay.
When you are appearing for the appellant and the delay, the same submission should be kept in mind.
My lord.
Heavy cost.
My lord.
You are for appearing for one only. And who is for the state? I don't think you have any objection, 47 days delay, let the appeal
So
be
far as
decided.
condonation of delay is concerned, your lordship may condone delay.
4 to 7 days, yes. Hertz, Mr. S. Mahanti, Learned Senior Counsel, appearing for the applicant, this in IA, huh? Rakesh Sharma. Along with Mr. Rakesh Sharma, assisted by Mr. Rakesh Sharma, Learned Counsel for the applicant. Applicant is appellant, huh? In 3505. This is an application for the condoning the delay of 47 days in filing the intercourt appeal being WA 1339 of 2023 from the judgment dated 3/4/2023 delivered in WPC number 14456 of 2021 by the single judge. Stop. Mr. T.K. Mohanty, Learned Additional Government Advocate, has appeared for the opposite the party.
Respondent 2 to 5.
Opposite party's number 2 to
5.
But
No, sir,
you-
2 to 4.
Why
I'm sorry,
don't you
2
give the total cost title? Suppose you are a senior counsel of this court. That registry is not supposed to go into the retable for finding who is the parties. When we are issuing a notice and interlocutory application of the nature of the condoning the delay, is itself an independent proceeding. Unless you can cross that threshold, your appeal will be dismissed. But these only that and others, well, from the notice will go. We don't understand this practice. Everybody should shun this practice. Give the entire cost title in the interlocutory application.
Yes, that's.
In other interlocutory application, which is.
Your lordship is correct, absolutely
Yes.
correct.
So we are, for the time being, we are looking into, but in future, I think this practice should
No,
be.
your lordship is absolutely correct. That is the mistake on their part. They should have given full cost title.
A division bench matter and thereafter sent to the single judge.
Madam.
Just as he said, FPS for the opposite parties, number 2 to 5. And your good name is?
Nirmal Chandra Das.
And Mr. N.C. Thus, and counsel appears for the writ petitioner opposite party number 1. Stop. Mr. Mohanty, Learned Senior Counsel, has submitted that the causes for the delay has been assigned in paragraphs. In paragraph 2. But in the paragraph 2, there is no cause at all. However, the counsel for the opposite parties have stated that they will have no opposition if the delay is condoned. This court, having taken an exceptions to the pleading, is inclined to condone the delay, and accordingly the delay stands condoned. This is not done. On the face of it, it should have been dismissed. You have not uttered a single line. Judgment is illegal, cannot be the cause for the condoning the delay. And other that it's unless the judgment, you will
Para
suffer.
5 and 6, he has tried to explain, my lord.
Where?
Para 5 and 6, he has tried to explain.
Para 5 and 6 of the which petition? Oh, sorry.
I am.
I'm sorry. No, I'm seeing a wrong petition. Just as has been explained in paragraphs 4, 5, and 6. 4, 5, 6, and 7. Stop. Those are the causes for pushing the file from one table to the other table. The law in this regard is well settled by the Supreme Court. Be that as it may, as the counsel of the opposite party, this para you will stand. Now we'll take the appeal, not today, I think. Some other day, or you are ready for the?
I'm
appeal?
ready.
You are
I'm
ready?
ready. I'm ready.
You are also ready? I think. Can be taken up the appeal today. All right. Yes, Mr. Mohanty.
This is a matter relating to
Yes.
the payment of ex gratia and meeting resolution, the writ petition has been filed. So two issues were cropped up before the Honorable Learned Single Judge. One issue, whether the resolution of the ADM meeting held by ADM, whether that is binding, who is a central PSU. And second, whether there was any policy or scheme of the MCL. It was found out that there was a policy. That is at para 28, the court has found out that is a policy. Now court has ignored that policy, and even if it has been stated that two persons have been participated in that meeting, they said that that is binding. Therefore, you have to pay 30 lakhs, though I have already paid more than 20 lakhs because my scheme says 15 lakhs and also some ex gratia, including I have already paid 15 plus 5 and some 20 odd lakhs. And contractual employee, because his father who had died in harness, that is, he was also a contractual employee. So there was no illegality committed. Because kindly see a CPSU, when there is a scheme, that scheme has to prevail over. The question is whether what your right is flows from the scheme, not from the document of the ADM. ADM has, it is only a recommended thing. If the ADM doesn't have.
No, just a simple question, because you'll be making argument on that point. That is, I am indicating to you.
Yes.
Forget about the scheme for the time being.
Yes.
Whether your representative participated in the discussion.
Yes, they have participated.
And they were duly authorized by you?
No. That is, kindly see, when there is a scheme.
Yes.
Because
no, forget about the scheme.
Your Lordship can see.
No, I am putting you a straight question, whether they are authorized by you or not.
They have authorized to attend because the meeting was called for.
Yes.
Because that scheme he has not challenged. Has he challenged that scheme? And if you would have said that scheme is unfair.
You also consider two situations. Your representative entered into an agreement that
Milord, this can't be called agreement. Milord, my humble submission
Why
is.
not an agreement? What is the
Milord,
definition?
your lordship kindly see the Milord, when a CPSU,
Yes.
Milord, a CPSU is not confined to one particular district. A CPSU is having the operation all over the Odisha. So, Milord, one officer from a unit, if he has represented for the
Come to
strike.
your counter affidavit, because this is very important.
Yes.
How the formation of this settlement was arrived at, that has been the basis of the Joint Single Judge's orders.
Learned single judge has stated that 2 persons have participated. So there is a promise by you. Therefore, that is binding on you. So learned single judge has also further found that there is a policy. Then learned single judge has not directed itself to find out if there is a policy, whether policy will prevail or not. My humble submission before lordships, because policy that is non-discriminatory. That is binding.
No, we are not on that issue. The issue is another ancillary issue to come up.
Yes.
For purpose of understanding that your challenge is that whether the authorized officer of your PSUs can make a promise going beyond this scheme.
They cannot be. On the face of it, they cannot.
What stand you have taken in your counter affidavit. That is very
Counter,
important.
it is.
If you have not taken any stand in your counter affidavit, will not in an intercourt appeal will not interfere with the judgment of the Lancing
Counter,
judge.
your lordship can see.
Yes. Where is your counter affidavit?
Yes, Milord, I have filed counter. Milord, those papers. Read petition has come. Will receive. Page 45, I believe.
No, page 45, I think something else.
Milord,
minutes. It's a minutes of this. What is the writ petition? Have you annexed the writ petition in the writ appeal?
Petition is there.
Oh. Yes. Come to your counter affidavit.
Your lordship kindly come to Miller. Page 44, internal page 5.
Yes.
It contains paragraph 8.
Miller, prior to that, if your lordship kindly come to from para 5, I will read. Para 5, Miller.
Yes.
That so far as prayer number 2 for payment of balance compensation amount 10,000 is concerned, 10 lakhs is concerned. It is humbly submitted at these opposite parties that board of directors of OP number 7 in their 372 meeting held on 25/9/2000 decided to make a payment of ex gratia 5 lakhs to the dependent of the deceased contract worker due to mine accident as certified by DGMS from 21/12/2016 onwards, which was communicated by general manager so and so. It is further submitted that VDA office order dated 14/11/2019, the amount to 5 lakh was enhanced to 15 lakhs by the board of directors of OP number 7 in their 394th meeting held on 11/11/19 as per the announcement made by the Honorable Minister so and so with effect from 7/11/19 in the to the next of kin of any employee, including contractors worker dying out of fatal mine accident. It is also humbly submitted that the unfortunate accident took place on 23/7/2019 in the mine of the Bharatpur, in which 4 persons had succumbed to the injuries. After the unfortunate incident of several meetings were held between government official, Collector Hon'Ble, Sub-Collector Talcher, Superintendent Police Hon'Ble, MLA Talcher, MLA Pallara, members of BJD unit Talcher, members of BJP unit, and Talcher Suraksha. All said meeting dated 31/7 was held chairmanship of Collector Hon'Ble. It is humbly submitted these opposite parties that in all said meetings held on 31, the authorities themselves have stated that the compensation will be made as per the existing policy. It is pertinent to mention that at the time of unfortunate accident, in which the father of petitioner along with 3 other persons succumbed to the injuries, the ex gratia amount fixed by these opposite parties to be paid to the dependent of the deceased contract worker due to mine accident was rupees 5 lakh as per Annexure A3. Therefore, these opposite parties calculated the compensation amount to be paid to the kin of deceased in the unfortunate mine accident, taking into account the compensation as per EC Act, funeral expenses, special relief in case of fatal mine accident. The calculation made in case of compensation to be paid in case of late Ramesh Das petitioner's father is rupees 5,56,000 plus 5 lakh special relief to the accident made came to 10,61,520. Same was paid to so and so. Then, my lord, it was further submitted here by these opposite parties that the announcement made by Honorable Coal Mines and Parliament regarding enhancement ex gratia amount from 5 lakhs to 50 lakhs during his visit to MCL on so and so. These opposite parties again made a payment of enhanced ex gratia 10 lakhs to Srimati so and so, mother paid or dated so and so. It is pertinent to mention here that these opposite parties have paid the compensation amount to the wife of late so and so, and these opposite parties are not in a position to pay more than what has been paid as the existing policy of the OP number 7. It is humbly submitted these opposite parties that it is a fact that some officers who had attended meeting on 6/8/2019 held under the chairmanship of Additional Collector Hon'Ble had signed the minutes of agreed to pay 30 lakhs in a special consideration as financial compensation to each of family of 4 deceased persons who have died in the landsliding at Bharatpur coal mines. The same has been reflected in the minutes of meeting dated 6/8/2019, Annexure 5 to the writ petition. It is further humbly submitted as these opposite parties that there was chaos due to the unfortunate accident and due to strike called by villagers, the mines were closed in the entire Talcher area. In order to normalize the situation and start the mining operation of coal, the officers of the opposite parties, being pressurized by the political dispensation and threatened by agitated crowd continuation of the closure of mining operation, had to accede to the demands of the villagers in the meeting held on 6/8/2019. It is pertinent to mention here that the kin of other 3 persons who had succumbed to the injuries said unfortunately have also been paid the same amount of 15 lakhs as ex gratia. In view of the fact that stated above, the balance payment of compensation amount 10 lakhs cannot be made by these opposite parties, taking into consideration A3, B3, and the prayer for balance of payment may be rejected. Then, my lord, your lordship kindly see para 9. So far, the prayer number 1 is concerned, it is humbly submitted that these opposite parties, it is a fact that the petitioner has been given a temporary employment under the security agencies number so and so, under whom the father of the petitioner was working, and after period of so and so, the security agencies wherever the petitioner is present is working under the Security and Intelligence Service Limited. So far as making positive recommendation of the name of petitioner along with 3 other kin of contractors who had lost their lives in the so and so concerned, it is humbly submitted proposals for permanent employee in next of kin for receipt and payment of 30 lakhs for each affected family was put forward before the functional director FD's MCL meeting held on so and so. The FDs of the MCL, the said meeting directed to submit the proposal to MCL board for consideration. According to the said proposal were placed before the MCL board on 218th meeting of the board of directors of MCL held on 4/9/2000. In the said meeting, both proposals were discussed in detail. In deliberation of the board meeting on 4/9/2019, it was clarified that as per the existing provision, the employment in the company is provided on compulsion ground to one eligible dependent on the regular worker who dies while the service or is declared medically unfit under the provisions of NCWA and also land ousted under the provisions of RR. In case of fatal accident involving contractor worker, the next of kin is provided employment in the contractor's establishment. However, so far the ex gratia concerned 5 lakh is paid to next of kin deceased involves in the fatal accident arising out of an course of employment, whether regular or contractual. It was further brought to notice of the board that the present proposal is providing employment through outside recruitment, which is done only to fill up the vacancies arising statutory designation, essential categories of paramedical staff after observing all requisite formalities and obtaining the approval of the CIL. Therefore, the proposal requires approval of CIL board and also due to recommendation of MCL board. It was also brought to the notice of the board that in fatal accident which occurred on the same day, that is on 23/7/2019, in another CPSU, that is Nalco Angu, which is located in the same vicinity, as per these political leaders and stakeholders, enhancement of the ex gratia. Nalco management agreed to demand and raised ex gratia amount from 8 to 15 lakhs. So in our case also, we have now paid 15 plus 5. However, so far as employment next to kin is concerned, it is agreed concerned that it would be contractor system. And others, they are paying 15. So that's what the company's policy. So once that is the company's policy, my lord, so now he should not have asked for this 10 lakhs or for a permanent employee. Permanent employment, that is not our feature. That's the, if his father had been a permanent employee, then it could have been. So that's the policy. So if you're not
that part, of course, we understand, because agreement also says a temporary appointment.
I have given.
Part is this financial assistant part.
Financial part is, I have given 20 plus. Kindly see it is 15.
So your own action shows that your scheme is not rigid.
Milord?
Your own action shows the scheme is not rigid. You can relax the scheme. You can also enhance the amount.
No. Milord, it has been enhanced.
Yes.
From 5 to 15.
So why don't you enhance to 30?
Milord, they have not agreed, Milord. That's the a policy, Milord, cannot be forced upon.
It is not a policy. You are changing the policy.
No. I am not changing. Milord,
how you can grant it? Your policy says it is only 8 lakhs for the dead person.
No, Milord, 8 lakhs was Nalco, then Nalco made it 15 lakhs. So also ours was 5. So we made it 15.
15.
Yes.
And you paid 20 lakhs.
No. Funeral and other whatever.
Oh, that is a 5 lakhs.
Yes, 5 lakhs. That 5 lakhs 60,000. So it comes to 20 lakhs 60,000. I have already paid. Above and above 15. Milord, kindly see, Milord, what is the, if I'll show, Milord, if your lordship will permit me 2-3 decisions I'll place. Milord, the entire, Milord, the essence is tied over the unfortunate situation. This is not a right. Milord, see, once a read petition comes, Milord, then
this is not a right.
No. Milord, kindly see. It is an exception to the right, Milord. Otherwise, public employment article 16 says that it has to be by way of invitation. But they have carved out an exception. That exception is if 2 things has happened here. One is with regard to accident and other with regard to if there is somebody medical incapacitated, then he will not go through the 16 procedure. Then he can be. And that is the source is only the policy. What policy provided for? In all decisions, the court looks into the policy. He cannot go beyond the policy. So now, Milord, the policy is with regard to 2, Milord. So far employment is concerned and so far my payment is concerned. And Milord, in both, Milord, I have complied with. I have complied with my, so far the employment. He has to be given a contractual job under a contractual basis that has been already provided. And he has to pay 15 Milord that has been considered.
So his employment is under the discretion of a contractor.
No, Milord, that he cannot, that contractor cannot throw him.
How do you say that?
Because it is under our establishment. Because and that will be, Milord, that your lordship may, Milord, direct to that extent that that we are not doing that termination. If your lordship by anything, Milord, if it comes to
your mine operation has been outsourced. Your mine operation has been outsourced.
No, not some of the, some parts, some works.
Some parts.
Yes, like security agency and others like this. Because then that is also, your lordship can see in security agencies, what is happening. Many ex-servicemen, they are coming in. So some local people comes in. So that is how his father was, kindly see, as he said, he was first given under a Dilip Kumar Dana. That's the security agency under whom his father was working also. The period of Dilip Kumar Dana was over. Thereafter, Milord, he is saying that he is now given under another, under Security and Intelligence Services Limited. So his service would continue. That your lordship, once that is coming to your lordship mind, your lordship may give some directions so that that will, Milord, that will comply with. Because, and what I find after taking from instruction, because there it's not a stopgap arrangement. It will continue. That's what my friend has said to me. So that part.
No, the problem is that these agencies, sometime on flimsy ground, they terminate.
Milord, that Milord, your lordship can, Milord, your lordship can, what I can say, Milord, if your lordship is coming, your lordship can put some conditions riders. That, Milord, your lordship, Milord, I feel the empathy. Milord, your lordship, that's the humanity that comes to.
No, not only the question of humanity.
No.
Because in the course of the employment, section 12 of the Workmen Compensation Act, I am not bringing that.
Yes.
Because they're different organization. It clearly says that when this contractor engaged by you, the employees working under, they should be, for purpose of this Workmen Compensation Act, be deemed as the employee of the principal.
Milord, there are certain decisions to that extent, Milord, what your lordship is correct.
This is a statutory provision I'm just relating to you.
Milord, there I will not join issue.
No, obviously cannot also.
Yeah.
Because this is the labor policy of the government of India. How can I, being a national public sector unit?
Milord, because I have no instruction and nor I will, Milord, join there, Milord. Only my limited prayer before your lordships, that as per the policy, he has been already satisfied. He has been given the employment. He has been given the payment.
No, the petitioner, the writ petitioner is not satisfied.
Milord?
Writ petitioner is not satisfied.
No, he cannot, Milord. My payment, as per policy, Milord, that is what I have complied with. Not satisfied, Milord, I have complied with. I have complied with, and that compliance.
What is the unfortunate part, Mr., that I am telling you, that you have, which lost the earning members.
Yes.
They are in the one side, and you are the mighty public sector unit on the other side.
No, Milord, Milord, my humble prayer before lordships, Milord, it's not that way, Milord. I do not want to put it that way.
It is a matter of only 10 lakhs.
Milord, it's Milord, I leave it to your lordships. Milord, I have to put only 3 case laws before lordships.
Yes, obviously.
Yes. So, Milord, my humble submission is.
We understand what you are just arguing before us.
Yes.
That you are only bound by your own scheme, not otherwise. Whatever decided.
No. I cannot go beyond that.
You cannot go beyond that.
Yes. And also, Milord, that should be the policy, because otherwise, Milord, there cannot be an uniformity. Your lordship, kindly visualize.
That I can give you at least 20 Supreme Court decision. What is their view about the policy? Policies are merely the guidelines to guide the authorities.
Milord, see, this is what my small endeavor before lordships. Milord, your lordship, Milord, these are the 3 decisions which I will place.
Obviously, you place your decision. We are just talking. You, the company, big companies are coming with and fighting with this son of a deceased workman.
No, your lordships, kindly see. I will also further submit. It is not that we are not. That way, we have not filed the writ petition. What we want to say before this honorable court is, and before my lord is, that since there is a policy, please, the policy has been complied with. So therefore, my lord, this is a uniformity we want to maintain throughout the company. So that's what our only endeavor before lordships. A uniformity, otherwise, that will be, my lord, everywhere. If another district, it will happen. Additional district magistrate, he may say you pay 35.
Mr. Mohanty, that your uniformity at the first instance was the 5 lakhs rupees to give the family of the dead workers.
Yes.
There is everything, even in the agreement, there is one issue is the consignability of these clauses. You must be very conscious about what kind of the agreements they are entering into. In Renu Shagor, you know better than when the
Milord,
Supreme Court even in an agreement
Milord,
says,
kindly see here, if your lordship will go, Milord, that a person who has gone there, he has no authority even to agree for this. Signing of
and
a document.
in the counter affidavit,
Yes, Milord,
I'm sorry to show.
No, counter affidavit he has stated, Milord, that
What
he has
is-
been pressurized.
That we all understand.
So, Milord, that has been, that is.
Show me that he was pressurized. There is any communication made by the two persons to your company immediately after the meeting was resolved. You
Milord,
cannot,
that was-
you
Milord,
just,
see,
Mr.
Milord.
Mohanty, being a senior counsel, you understand the court will not permit you to take a defense in the counter affidavit.
No, I
unless it
cannot.
reflects in the
I
records.
cannot.
And that
I
is
cannot
what.
take any other ground which is not there, and I cannot take anything which is not in the counter, and also counter whatever he has stated.
No, just try to appreciate. I'm just pointing to a certain aspects of the matter. You show these two representative of yours who participated in that negotiation. You first says they are unauthorized to take a decision in regard to the quantum of the compensation.
Nowhere that is such a.
That is number one.
Yes.
Number two, that now you are saying that in the counter affidavit they have stated they was pressurized. And counter affidavit was filed after how many years?
Not years, Milord.
At least 1.5 years, perhaps.
Maybe.
And before that, there is no communications to you by those two officers that we are pressurized. You are
Milord,
forced.
that part, Milord, that is, Milord, your lordship, Milord, there is no document. So I cannot.
Mr. Mohanty, as a
No, I
court
cannot,
of-
Milord, I
court
cannot
of
improve.
equity, just wait.
Milord, I cannot improve whatever stated here.
Exactly so.
Yes, I cannot
Exactly so.
improve.
Yes.
I cannot improve. Only my.
Already, what decision you like to rely
Yes,
on? Give
Milord,
us
three
the
decisions I will place. One, I will first 2010-11 SCC 661.
Of the list with you.
Para 8, Milord, your lordship kindly, I'll just take it to para 8, Milord. Para 8, 6 lines I will show from them.
It is relating to the compassionate appointment.
Yes, this is a compensation appointment. Milord, para 8, Milord, may.
Yes, please.
Milord, it is now well settled that the appointment of a compensation ground is not a source of recruitment. On the other hand, it is an exception to the general rule that the recruitment to public services.
We have no problem. We accept all the proposition.
Milord, your lordship, Milord, I'll just go 5, 6 lines. Milord.
Read, we know this law.
Yes.
If you want to, just read. Read this part. We know all the note. This not cannot be the source of employment. Nobody has ever claimed that it is the source of employment. It is always for the tiding of the immediate economic stringency of the deceased family.
Milord.
Yes, and that is subject to the scheme also.
Milord.
So this law is well known to us. Next, yes, I have noted that.
Your lordship kindly, Milord, 4, 5 lines I will just place.
Yes.
On the other hand, it is an exception to the general rule that the recruitment to public services should be on the basis of merit and by an open invitation providing equal opportunity to all eligible persons to participate in the selection process. The dependents of the employee who die in harness do not have any special claim or right to employment except by way of concession that may be extended by employer under the rules or by a separate scheme to enable the family of the deceased to get over the sudden financial crisis. The claim of compensation amount is therefore traceable only to the scheme framed by the employer for such employment.
Yes.
And there is no right whatsoever outside such scheme.
All right.
So, Milord, I am just giving that, Milord, this
All
is the
right.
emphasis.
All right. We know this law.
So other 2 decisions I am giving, Milord, since your lordship, Milord, that is also to the same extent. And Milord, that has to be, Milord, taken note of. I am giving 2 other decisions, Milord. There another is, Milord, 2008-13 Supreme Court cases. Milord, I am not read out, Milord, the paragraphs I can indicate. Para 9, 13, 10, 9, 10, 13,
Yes.
18, 19 and 35 is with regard to policy.
No, you are referring to first 2008 13 SCC.
Yes, 730.
730. What is the paragraphs you are referring in this?
Milord, 9, 10, 13, 18, 19 and 35 is the policy. With regard to policy, the court has stated.
All right. Another decision?
Milord, that policy, Milord, if your lordship will just take, Milord, the policy 1 minute, Milord, para 35.
Yes.
Milord, para 35 at page 748, fourth line. Milord, from starting I am reading, the issue is not what is most advantageous to the government servant, but what is actual term of scheme. The question is not whether the interpretation which is more advantageous or beneficial to the government servant should be adopted. The question is whether policy which it stands, which is clear and unambiguous, is so unreasonable or arbitrary or absurd as to invite an interpretation other than the normal usual meaning. Matter of policy are within the domain of executive. The policy is not open to interference merely because the court feels that it is not practical or less disadvantageous for the government servant, but whose benefit policy is made, or because it considers that more fairer alternative possible compensation appointment being an exception to the general rule of the appointment can only be claimed strictly in accordance with the terms of the scheme, not by seeking relaxation of the terms of the scheme. This is what I.
Okay.
And 2014 also, Miller, to that extent. 2014, 13 Supreme Court cases 583.
And there is a very strong decision in favor on the policy matters 2007, authored by Justice T.S. Thakur. It says the fundamentally this kind of this compassionate appointments all stands against the Article 14, and that should be scrapped.
No, it's not. That is how court has not scrapped.
No, that is why.
14, 16,
why
because they said,
they
said it is an exception, and this exception has to be based only on the policy.
On the policy.
Yes.
But here is the claim is based on a separate resolution.
Miller, that Miller, whether such a contract can be, Miller, that is valid or not, that your lordship, Miller, my submission is that the persons who have been gone from a Miller that to additional district magistrate, he is not authorized to discuss all these things. Miller, his job was.
What is the extent of authorization?
Miller, kindly see, the additional district magistrate has called for the meeting with regard to strike. So that is impossible. So during that
letter, have you annexed that letter with the counter affidavit? The intimating you please attend the meeting? Then
letter, there was no letter.
So you went there.
Yes.
Now how to get that? What was the purpose of that meeting? Because
Miller, because that minutes itself.
Minutes, you just come to the minutes. I have looked into the minutes.
Minutes that
come to that minutes. Para 7.
In that minute.
No, this is not the minutes. Para. This is paragraph 6, I think, yes.
Miller, that English translation, that is annexure 1 at page 28 of the writ appeal, and my friend has given an English translation also of that. That is at the last, at the bottom.
That is, I think, the minutes as annexure 6, right?
Annexure 5, yes, ma'am.
Annexure 5. No, 5 is the office order. Annexure 6 is the minutes.
No, my lord, annexure 5 of the writ petition.
Oh, all right.
Writ petition. The English translation we have submitted before the.
In the writ appeal also, I have given the English translation. That must be at the last of the, because the office keeps it in the last. The writ appeal, I have given the English translation of annexure 1.
Okay.
The first page. First page, Mirror, the third paragraph starts with, at the beginning of the meeting, Sub-Collector Talcher welcome to the all officers, all villagers who were present in the meeting. Then the Sub-Collector put forth the facts before the meeting regarding rehabilitation of the families of the person who have died on 27/8/2019 because of landsliding at Bharatpur coal mines, and how the coal mines would function, which has been closed since 14 days due to public agitation. That's the Miller, the purpose.
This is the annexure 1, the translated copy. Then the proceeding of the meeting dated 6/8/2019 held at such and such in presence of the MLC authorities regarding the rehabilitation of the families of the persons who had died on such and such and such.
That same, I'm reading out the third paragraph.
No, it's all right, but you are
Yes.
saying the purpose of the meeting was discussed.
No,
about the
purpose,
strike.
Milord, because there was strike for 14 days.
No, whatever.
Yes.
The purpose of the
Yes.
meeting was not to discuss about
And
the
Milord,
strike.
your lordship, can you see, Milord? The purpose was, Milord, that how that is.
The purpose is written in the proceeding minutes.
Milord, that your lordship, can you see, even the para 5 even last, the district has requested public and people representative to withdraw from the agitation because of national interest. So it was, Milord, the purpose was how the agitation has to be solved. And there, Milord, they have stated that you do this and decided that a positive recommendation, then 30 lakhs you pay. Unanimous decision was taken in the meeting that in a special consideration, a sum of 30 lakhs only has to be financial compensation to be paid to each family who have died in the lands and who were present in the meeting, agreed and paid the compensation amount partly in shape of check, affected, promised to rest outstanding. So this has been taken. So if your lordship will go by this para 2, that's it. That is only that is para 2.
That is what exactly.
And this is the additional collector.
Mr. Mohanty, one thing, this traveling through my thought process, that is why I'm sharing with you.
Milords.
That some officers, 2 officers, and we believe they are the very responsible officers. Otherwise, you do not authorize them to participate on your company's behalf in the meeting.
Milords.
If they are pressurized,
yes,
they were threatened,
Milords.
they would immediately report it to you because they have signed certain documents.
Milord, what?
No, just wait. Let me finish. Certain documents. It is very pertinent in nature for purpose of rehabilitation of the families who lost their earning members in the accident. You place any document in a counter if the answer is no.
There is no document.
So what will be the court will presume from this action?
Milord, my humble submission once again.
No, your submission we understand. Your submission that whatever the resolution has been taken,
yes,
that has no validity because you have a scheme.
Not that. Your lordship, please. That is Milord second. Milord, who called for meeting? And
whoever.
Kindly see, Milord.
Whoever.
Milord, no. Milord, your lordship has to.
How does it relate to your scheme?
Kindly see the source of authority. Milord, a person, kindly see.
Yes.
Milord, who can give a direction?
Yes.
Who can give a direction that has to be seen?
Nobody has given you direction.
Yes, Milord, see kindly, see even settlement.
You read para 2 again of your translated copy.
Milord, your lordship, kindly see, Milord, kindly give a thought, Milord. Milord, if a person will go, assuming that he is a responsible officer, and the ADM has no authority. Milord, my humble submission before lordship.
Don't go in that meeting if you are the questioning that.
No. I have to go to meeting because he is the law and order authority.
Yes.
My impasse is 14 days has been closed.
Yes.
Milord, unless I attend, Milord, that cannot be resolved. So, Milord, one hand, your lordship kindly see this. And second hand, I have a policy. And your lordship, if your lordship will find out the lacuna is that the officer who has signed, he has not reported it immediately saying that he has pressurized.
No, that I am not that. I think there is no contemporaneous document to show that there is any coercion or duress over your officers.
There is total lack of contemporaneous document with regard to his pressurization.
Yes.
Milord, even if somebody assumes that he has accepted it, can such acceptance is binding on a company in view of a policy? Milord, I am coming to the highest position. Even if 2 officers has gone, they have signed a document. Can that be treated that yes, it is a contract and 2 persons entered. So therefore, this has a more binding effect than your policy. If Milord answer is yes, then I have no case. Because why I'm saying? I'm saying because of I'm a CPSU, I'm an authority within Article 12. The policy has to be seen. Who has to formulate the policy?
Yes.
And that policy.
Mr. Mohanty, I am time and again saying in this, a policy is a guidance. Policy is not the law.
No, no, policy, it's not a question of policy of not law. Policy is binding on me unless he challenge and say before your lordship.
Nothing to challenge the policy.
Yes, he should have challenged.
Why?
Milord, he should have said that the policy, Milord,
You are going out of your policy through two officers. He has seen this occurrence in the just I'm telling you how he has looked at it. He has that the officers is coming out of their own policy and now have entered into an agreement. They must.
No, no, he cannot, Milord. See, he agreement, Milord, this can't be termed as an agreement. And this can be termed that this is binding because see, two officers entering.
What is the agreement, Mr. Counsel?
Milord, agreement is in first is that one has to find out. I have not sent him that you go and discuss.
That is a separate issue.
So that's
no.
That has to, that is.
No, there is a two separate issue. First of all, whether this is an agreement. You cannot say it is not
an agreement. According to me, this is not an agreement.
Not agreement because you say they are not the authorized to sign on my behalf.
Yes.
That is there.
Yes.
That is the only issue that is not.
Yes, that is.
But
and further, it was not known. I was not knowing that a issue has to be decided.
And what action you have taken against your officers?
No, Milord, see kindly negative equality, Milord, that principle is there.
I understand that, but
if you say negative equality, because I have not taken an action, therefore it is fair. No, that's not. Milord, what has happened here? Let us not assume. You will actually go to take it to the highest. I was not knowing.
Yes.
Milord, the onus is on him to show that yes, letter has been given, that it would be discussed this, and you sent two officers.
And those letters are non-existent letters.
No, there was no letter.
That what?
So it was just a meeting was called to resolve the issue how the agitation has to be get over.
No, that you are interpreting now because the purpose of the proceeding has been well laid.
No, your lordship kindly
just heading. Don't go to the paragraph.
Kindly see this.
You just read
this paragraph is after the meeting.
Is a proceeding.
Yes, but what is the purpose of meeting? That is in para 3.
This is also the purpose of meeting.
No. Heading comes. The proceeding comes after the meeting.
Yes.
Proceeding comes after the meeting. What is the meeting?
You read para 3 at the beginning of the meeting.
Yes, at the beginning of meeting, the sub-collector Talcher welcomed all officers and all villagers who were present in the meeting. Then the sub-collector put forth the facts before the meeting regarding rehabilitation of the families of person, those who have died on 27/8/2019 because of the landsliding at Bharatpur coal mines and how the coal mines would function, which has been closed since 14 days due to public agitation.
So this purpose of the meeting is regarding rehabilitation?
No, rehabilitation, similar rehabilitation, it is first, this is the since 14 days, then the rehabilitation. If assuming that
14 days,
not assuming two things are there, and if two things are there, can Milord the officer, even the ADM, cannot go beyond my scheme? I'm putting that question to myself.
ADM doesn't have any role. He's a facilitator.
No, Milord, he is now, Milord, this is the.
He's a facilitator.
No, this document has been, Milord, the basis for the writ petition. So here the ADM has given this proceeding. So that became the basis for the writ petition.
You have to just understand this document that has been just.
Yes, Milord, I'm making a question to myself.
In the presence of the additional district magistrate, that's all.
Yes.
He is the facilitator.
Milord, a facilitator cannot, Milord, he can formulate a policy for me.
No, he is not formulating.
Yes.
You are agreeing that you
not Milord, agreed, Milord, that's it.
That must differentiate.
I with all my.
You can say that it is not valid. I am not.
Yes, Milord, that's my submission right from beginning, Milord. This agreement, this is no agreement.
And it is not binding on you because
because
you have not authorized anyone to sign such agreement.
To discuss with regard to rehabilitation and further the amount which. And also this.
First of all, amount will come later on.
Yes.
You have not allowed the officer to discuss about the rehabilitation.
Because Milord, that
come to the counter affidavit again.
Milord, counter, Milord, I have already read out, Milord.
There is nothing like that.
Yes, Milord, that is the only paragraph is that.
You have stated the officers who have pressurized?
Yes, and they put it to attend. They have been pressurized, they have signed it.
Yes.
So that's
your stand.
Yes.
Thank you.
Yes.
Yes, learned counsel for the petitioner. What is your say? How it is binding on this company, this
My lord,
corporation?
My lord, the petitioner is a layman. Petitioner is a
No,
layman.
but talk in terms of law.
My lord, Lordship may kind of seen that annexure 5.
Yes.
Annexure 5, the heading, your Lordship has already read this, and your Lordship may kindly see, they have taken a decision that unanimously, my lord, at page 2, it is decided that one member of the person who have been died in the accident of landsliding will be given appointment as per qualification. Now a temporary appointment will be given to him, and the salary will be paid as per the salary fixed by the High Power Committee, which is more than 20,000 per month. It was also decided in the meeting that a positive recommendation will be made by the MCL board to the Coal India Limited within 1 month for permanent appointment in MCL. Thereafter, my lord, unanimously a decision was taken in the meeting that in a special consideration of 30 lakhs only, as the financial compensation will be paid to each family of the 4 persons who have died in the landsliding at Bharatpur coal mines, and immediately.
We have read this. The question that Senior Council has raised is that the officers who were attending the meeting,
my lord,
they did not have any authority to agree on these terms.
Yes, yes. Next slide, my lord.
Yes.
Who had died in the, and immediately the officers of MCL who were present in the meeting agreed and paid the compensation amount partly in shape of check to the affected families, and strongly promised that to pay the rest outstanding compensation amount by deducting the check amount from the settled amount of 30 lakhs by 10/8/2019. They have agreed and they have paid that this
issued the check also.
Checks also. Partly they have implemented this proceeding. Now they are saying that balance amount will not be paid as per the policy decision. We are not coming under the policy decision. We are not taking into account that policy decision. We are only concerned with this particular annexure, my lord, annexure 5, that is the proceeding under annexure 5, my lord.
All right.
And thereafter, my lord, in the meantime, they have also given appointment to the petitioner in a temporary basis, my lord.
You should not have any grievance because this is in conformity to this agreement.
Yes, my lord. My grievance is only my permanent appointment be considered after the recommendation of the MCL as per the.
All right.
Anything to ask? My lord, your lordship, my lord, I just interrupt, my lord. There was a line he has read that it can be recommended to CIL for the permanent. That, my lord, your lordship can direct.
No, that you have already fairly submitted.
Yes,
That part you may, for protection of the employment.
Yes, for protection, yes. That is whatever your lordship may, my lord, cause that. So that recommendation will do. Because courts, yeah, that the recommendation that he should not be dislodged.
CIL was not a party to that.
Yes, yes, party that.
No, he
Opposite
was
party number 7.
He is
Where?
party number 7.
In repeat.
To that agreement.
No, not agreement. He was not.
No.
Agreement. He was not. Yeah. And I am a subsidiary, and as your lordship tell it, I am a subsidiary of CIL.
Yes.
And this policy is for the entire CIL. CIL is for the whole country.
Final decision has to be taken by them on your recommendation.
Yes. So your lordship may, Lord, at best a recommendation, if possible, that we will forward it.
And if the policy is there also, any deviation from the policy will be by the
CIL. Because that deviation has to be done. Because these 15 lakhs which we have enhanced, we have sent it to their approval. They have approved that. After they have approved, so this payment.
Just one clarification. If the officers were not authorized, how they have issued the check in just.
No, check after the approval of 15. 5 lakhs.
That check in the meeting, I think.
Yes,
No.
Yes,
No.
Can you say that? What is the amount of the check?
It is recorded in the meeting that check was handed over. What was the amount?
He has, counter he has written. 5,36,000.
Yes, also I have given on which date we have made.
So that is there in the meeting.
Yes.
And then
No.
That 5,36,000.
So that is according to the policy.
Yeah, according
Prior
to
to the meeting, 5 lakh was paid. prior to the meeting. 5 lakh and 5 lakhs for work on compensation, funeral and all those. 10
Just a
lakhs.
minute. What?
Given the dates.
Again, 5 lakhs where?
5 lakhs the compensation amount, another 536 with regard to this funeral and EC and all. So 1036 that has been given. Now after the enhancement, another 10 lakhs we have given. So therefore 1036 plus 10, that becomes 20 lakhs 36,000, and that 5 lakhs has been enhanced to 10 lakhs, 15 lakhs.
No, so that 15 has been approved by CIL.
CIL. After approval, that has been.
Oh, okay. Sorry.
Those approvals are annexure.
Millard, he has given in the counter, Millard, my friend, because he has given in the counter.
Counter to the writ appeal.
No, read
In the petition and
Oh,
as well as
Mr.
the
Sharma
recapitule
has
also I
given.
given.
Mr.
In the
Sharma.
recapitule also it's there.
All right. Who are the opposite parties number 4 and 6 in the repetition? Or these are state special land acquisition officers?
Millard, the government.
The government, yes, they don't have any.
They don't.
All right.
Because they are the author.
But Mr. Sanjeev Mohanty, senior counsel, listed by such and such. And also Mr. Senior counsel listed by Mr. Rakesh Sharma, counsel, and Mr. N.C. Das, and counsel appears for the repetitioner respondent. Judgment hearing is complete, judgment is reserved. Thank you for assistance.
Item 19.
MCL is directed to file further affidavit. This matter being heard number of times before my Lord Chief Justice.
Yes.
The Honorable Chief Justice was also satisfied that the basic amenities or house building assistance has not been provided by MCL in spite of repeated reminder given to them since 2013.
Yes.
But now further direction was given, especially addressing Parawai issue raised in objection affidavit.
Whether they have filed any affidavit?
They have filed on 5th.
Okay.
And 4th.
So 4th or 5th copy I received.
All right.
So 5th actually I contacted the persons, 105 displaced persons actually, 105 out of 155. They have not been provided anything. But I was trying to get an application filed, a lawyer commissioner be visited spot to find out. They say, with due respect to the officers, they don't speak the correct statement. They don't speak the exact fact.
Then you file a short affidavit.
Right.
Right. Because otherwise, they are stating that we have done it.
Exactly. Exactly.
You just say, just file it.
I'll file a short affidavit and also an application.
Your Lordship, see the only writ appeal prayer. What is the prayer in meditation?
Sir, court has expanded his power to say public interest litigation. But here, Your Lordship, allow me to file a short affidavit as Your Lordship rightly indicated. And I also filed an application. If Your Lordship will feel convenient to depute a person to go and make a spot visit.
No, that is the writ appeals there. They should not be evicted. That is the main prayer.
Yes.
That is the main prayer. There should not be eviction drive because they are trying for a settlement. We can all understand. Someone is urging for the amenities from the MLC is that they want to stay there.
105 persons will be thrown out. Like garbage.
But my limited prayer, which is not cause prejudice to my Lord Senior, that they may not be hinders for the development of work, my Lord. They are create hindrance in development work. I have filed affidavit in court. And there is a letter to the sub collector also and Tata Power.
Suppose their hearts hinders your development work, right? So you will evict them, right? So since you are not in a position to evict them, you perceive it is a hindrance to the development work.
No, they are deliberately.
Council come out clear that ultimately you want to evict them. You are entitled to evict, but follow the Supreme Court's direction in Olga Tillis.
I have followed all the Miller's development work was done. Miller's
Sir, with due respect, nothing has been done.
Miller's plot.
Anybody here from here?
We are fixing the matter on 28th of July.
Right.
In the meanwhile, if this,
Millards, 1st of August, Millards.
1st of August?
20th more.
all right, if you have any difficulty, 1st of August you want, all right?
Only one line, Millards, may not create the hindrance.
This is a dangerous line. This will be a dangerous line. You file an application, how they are obstructing you.
Millards, I have filed affidavit to that extent, Your Lordship, see that.
Because this omnibus order we cannot pass.
Your Lordship, see my reply, Millards. See the reply, Millards.
No reply, please. That is what I have to answer. But if your lordship looks at the interim order is there, Chief Justice,
No
Chief
interim order
Justice
is there.
heard.
Your Lordship, no interim order is there. Millards, I have.
No, I understand. No interim order is there because the main this prayer in the this writ appeal is that no eviction. But how can there be an interim order? Is there, but you cannot just destabilize them now.
Prayer is that, Millards, till the physical allotment of plot. I have allotted plots, Millards, and given a temporary accommodations of quarters, mean all the
that has been declared. That has been declared unsafe by them.
Please.
It's a dilapidated house.
Single judge order is give a temporary accommodation so that they have evicted because mines is at the edge of village, Millards. I have filed some. That is just also safety concerns, Millards.
It's all right that we will consider. Let them file an application. Let us see. 1st of August, we'll consider all these aspects. We are not passing any order. If you want to file a supplementary affidavit showing how they are creating hindrances, here in the affidavit you have
Yes,
dealt
I have categorically stated that.
Well, I'll highlight details, each and every aspect which this has not been complied with. And I request your lordship to deputy a person, advocate, a senior advocate, or any advocate to go there and verify. If I am wrong, sir. I'll sit down.
Then it is not cause prejudice, Millards, they are not to create hinder development work. No, I have not evicted them. Development work at RR site, Millards.
Just wait, but you have waited so long for a few months, few days only wait, that we'll decide. We'll try to decide finally on that day.
Development work at the site which has been allotted to them.
Exactly. I have allotted plot, labeling work over.
I've given the photographs, it's there.
No. If you have not shifted there, then why are you obstructing them?
Exactly, Millards.
No, I have not shifted, Millards.
Shifted.
I'm not saying at the place where you are staying now, where you don't want eviction.
Right.
He's saying that the new place, there you are.
No, sir. Sir, let them file an affidavit to the.
I have filed. Already filed with letters, Millards.
I'll give a reply. All these are.
Your Lordship, see that 432 letters.
In the guise of that order, they're trying to throw us out.
All right.
Millards, 432
At the request of Mr. SP Mr. Planet Senior Counsel is stated by, what is your name?
Omkar Panda.
Mr. Omkar Panda and Counsel appearing for the appellant. Let the matter be listed on 1st of August. You want 1st of August, 1st August 2023.
Millards, in the meantime,
to file
shall may be directed to do development work.
What is your good name?
Devraj Mohan.
All right, Mr. Devraj Mohanty, and Counsel, who is appearing for the Mahanadi Coalfields Limited within bracket MCL.
I'll be filing
has
affidavit.
submitted that the petition, these appellants are creating serious obstruction in the development work.
RR site. RR site.
Sir, rehabilitation site.
Development work relating to the
RR site.
At the rehabilitation.
Rehabilitation and resettlement site.
At the rehabilitation and resettlement site. Stop. To stop, the Mr. Mistral and Senior Counsel has seriously contradicted their statement, stating that in terms of the order dated 23/3/2023, which is the last order, and similar others orders were earlier also passed, the MLC has not provided the basic amenities to that site, where they are showing the appellants have been rehabilitated stuff. Be that as it may, we permit the parties to file the supplementary or additional affidavits by the next date. There shall be an attempt to hear the matter on merit on the next date. As Mr. Mohanty has submitted that because of this situation, because of this situation created by the claim and counterclaim, the development work of the MLCs came to a halt. Okay, that should be immediately removed. Okay. On the next date, come prepared for the final disposal. You are appearing there.
Item 20. I'm sorry, my lord, I was on my legs.
You are not there. That is why, Mr.
Another thing is, means
Mr.
mine is at the edge of the village.
You appeared for such and such. You are appearing for whom?
Well, item 20, I was on my legs. I'm sorry, my lords, I missed the matter. on
No,
call.
already you are reflecting. He mentioned your name.
No, the lordship, my lords has fixed the matter on 17th. I have some difficulty. I'll on 18th, can your lordship calls? I'll inform the petitioner, and Mr. Mahanti's briefing counsel is here.
What is the agreed
Sorry.
date?
Lordship-
Senior counsel is suggesting for 18th of
18th.
August.
No.
18th.
17th Rastala.
Yeah.
18th. One more. day.
18th,
Just
Just
one more.
17, 18. Okay, it's done.
Great.
It will come on
Another
first.
submission is that
First.
Millards, another submission is that
So Mahanti, who has appeared for the
mine is at the
appellate
edge of
today?
village, at the edge
Mr.
of
Palit,
village is top
who is
of
the counsel who
Millards,
entered appearance
lines,
today?
There is a safety reason, Millards. Your lordship may indicate.
Who is the counsel who entered appearance today?
But the site where the villages are there,
Petition. I'll
that is
inform.
at the edge. We have given the photographs. It may collapse and it will be fatal to the persons who are staying there. If lordship sees the photographs, the mines is here, the village is here, and it has been
Please
excavated.
explain by filing in a supplementary.
We have filed it by affidavit and photographs. We have
Already,
filed
that
that.
is there we can look into, because we have also permitted to file further affidavits if you want to file.
Right.
Already.
First, right.
Please call the next matter.
Item 22.
Yes. And he was appearing for the petitioner. 22. You're there?
My lord, I am there for the petitioner. My lord, this is a case under rehabilitation assistance scheme that is covered by your lordship's recent judgment. My lord, have already held in WPC number 2007 by 2021 and batch of cases that the date of death of the person employed, that must be taken into consideration.
So
The
these are
lordship
also
has-
the another series or what?
No, not series. They are- Here,
This
your
is not
lordship.
that case.
Here, your lordship. I am placing.
This is not that case.
Yeah, I am placing your lordship. I am placing the fact. My lords have held that the date of death would be the relevant date to consider. On that day, the law existing, that is to be referred.
No,
That's-
of course, in view of the Supreme Court decision.
My lord.
From the same rehabilitation scheme, Supreme Court has
My lord, my
decided that.
Your lordship, in this case.
This case is different.
All right, we'll hear.
Yes, your lordship.
Are you ready for today or some other day?
Some other day I have filed a counter here, my lord.
No, I have
Yesterday-
received the counter.
Yesterday I have filed a counter. Your lordship can fix it to another date for final disposal.
No, my lord, with respect, my lord.
Not on record, we'll call for it.
Yes, my your lordship may call.
They have filed a counter on Friday. I have got a copy. I have no objection to that. To my read, they have not replied anything.
On 28th of July.
Yes.
Your lordship, on the last occasion
31st
directed that they must not seek time.
Along
My
with
lord, on the
counter.
last
No, they will not see, but counter affidavit also not before us.
My lord.
Mr. M.K. Khuntial, an additional government advocate appearing for the opposite party stated submitted that they have filed the counter affidavit on Friday, this 7/7/2023. They said counter affidavit is not on record. However, Mr. A. Mistral and counsel appearing for the petitioner has stated that the petitioner has received the said counter affidavit. Considering the nature of controversy raised in the writ petition, let the matter be listed on 31/7/2023 for disposal on merit. No accommodation on that day will be provided by this.
Yes.
May I pray your lordship any earlier date because it is covered by your lordship judgment.
All right, this is 31st only because our board is congested. He is not agreeing.
My lord, calling it on 31/7.
31/7/23. Call the matter.
23.
May I please, your lordship?
Mr. Mudali?
Yes.
I 381.
I have 10157. That is not on board.
Oh, that is great. Can you just bring the file? Just
10157 of
all right,
20.
Mr. Modi, you will take up after some time. Calling for the records. It will be taken up to some time. Because the interlocutory application that has been filed by the state is not on board.
Your Lordship.
Bringing that record.
A short date may be fixed, Your
What
Lordship.
is the number? We are passing it over, calling for the
Your
direct
Lordship.
because it's not there.
IA number 10157 of 2023.
It's filed.
The file there is no doubt. What is the period?
Call the matters.
When did you file?
67.
54.
Right, please, Your Lordship. There are several matters, but WA 1258 of 2022, Your Lordship had issued notice and passed some interim order. I think in my case, that will cover up all the cases so far the petitioner are concerned, including the case of Dr. Lenka also. Your Lordship, I have prepared a very short date chart for Your Lordship because last time Your Lordship have asked us to prepare a very short chart.
All the real petitions, the council are there.
My other, in one case, Mr. Nanda is appearing.
Yes.
The another case, Madam Pamirath is appearing. So all in my side, all in my side. And Dr. Lenka's application little bit different, but so far as my argument is concerned, let me place, then you will have his submissions.
May I submit my? No, I have received the instructions in REIT appeal 1255 of 2022. And there, my lords, directed on 2/11/2022, my lord passed a reason order to recast the merit list. Accordingly, it has been prepared and kept in a seal cover. So, Lords may grant me short time. I will file the same by an affidavit.
I think that interim order was there, but Your Lordship, hear me. If necessary, my grandfather will produce that. That is for Your Lordships to see. But just I am taking to Your Lordships to my date of appearance.
No, what is the problem in compliance of our order?
So far the compliance of the order is concerned, Your Lordship had directed that let them, pursuant to order of the single judge, let them revise the list and they let them call for those persons for a computer test and you produce that in a seal cover. That was the direction. That was the direction. So, but I am going to Your Lordship to take my entire submission would be, if you also look to the date chart, I can make.
Let us produce. I don't think that matter could be completed even today.
Yes, that.
So next date you fix.
Yes. That will get. Yes.
That means state is not agreed by the order of the single judge.
No, state has not prepared. Right.
This should have.
In a fast matter. Just
Yes,
Mr.
just a minute. Keep this
19/7/2012.
No, yes, Land Council, what is
Is for the Board of Secondary Education.
Fast matter, a copy has been served upon me in the faster manner. I will take instruction at least in this matter.
What copy has been served on you?
Copy of the REIT appeal in the fast matter.
Today.
1437.
I think Dr. Lenka has filed an appeal. Yes, he served it.
But he served it today.
No,
Yes,
I telephoned because he was in he was at Jagatsinghpur, his native place. Therefore, I could not serve since last 3 days.
Email, WhatsApp, everything is there.
He was telling me if necessary, he has actually absolutely no role to play. Subject to your,
that one thing you can do, you just be there comfortably, take note of because it will not complete today. So it will give you some more time. The next session of hearing, at least there will be 7-8 days difference. So you take note and we here continue with the hearing.
Grateful.
Yes.
I'm just placing my date chart. 19/7/2012. On 19/7/2012, the collector Jagatsinghpur invited application from eligible candidates for recruitment to the post of junior clerk for the registration offices of Jagatsinghpur district under revenue administration. In the said advertisement, let's say kindly mark this. In the said advertisement, total 10 posts were advertised, out of which 1 post was reserved for scheduled caste, 1 for scheduled caste women, 1 post for scheduled tribe, 1 for scheduled tribe women, 2 posts for SCBC, 1 post for SCBC women, 2 posts for UR, and one post for UR women. That is Annexure 1 at page 29. 18/6/2014. Pursuant to such advertisement, written test was conducted and its result was published on 18/6/2014, and the successful candidates were called upon to appear in the computer/practical viable test, which was scheduled to held on 30/6/2014. That is Annexure 1 at page 34-35 of the writ appeal. On 30/6/2014, on the scheduled date, computer/practical/viable test of the successful candidate was conducted. On the very same day, marks secured by them was published. Further, on the same day, 9 candidates were finally selected for the post of junior clerk, and accordingly, appointment order was issued to 9 candidates, including the present appellants, and amongst 9 candidates, 8 joined and 1 candidate resigned. That means out of 10, my lord, 9 candidates, including the present appellant, were selected. Out of the 9 candidates, 8 joined, but 1 of them resigned.
Yes.
Candidate joined and resigned. So 7 candidates were appointed. Those are the appellant before lordships. In 2014, after joining of the present appellant, one of the unsuccessful candidates.
8 has been.
8, yes.
Not 7.
8 joined out of 9, and out of 8, 1 resigned. That means 7 remain.
Oh, this means.
7 remain, and
I thought that the remaining candidate out of 9 has resigned without.
No, it's a little
So
bit, yes.
out of 8, 1 is resigned.
Out of 8.
All at the 7 candidates
Yes,
continuing.
yes, sir. 7 are continuing as such. That's right. Then 2014, after joining the present appellant, one of the unsuccessful candidate, Vijay Kumar Parda, he is respondent of 5, who was the petitioner in WPC OSC number 2373C of 2014, filed an original application challenging the result of the written test and final select list, and accordingly, after evaluation to give him appointment, that is his prayer, after evaluation to give him appointment to the post of junior clerk. Then 24/3/2015, pursuant to the appointment of the present appellant and other successful candidate on 24/3/2015, some unsuccessful candidates submitted written complaint before the collector Jagatsinghpur, alleging that OMR valuation and result sheet of the candidate have not been properly evaluated as per the answer key provided by the Board of Secondary Education, which they have obtained under the RTA Act. Then 4/5/2015, the Secretary Board of Secondary Education addressed a letter to the collector informing that due to inadvertent mistake, the set of question paper, that is B, C, and D, were not jumbled in respect of paper number 1, and accordingly the result was revised and handed over to the authorized officer. Then 6/5/2015, the collector convened an urgent meeting of the selection committee on the same day, and the collector sought for necessary clarification from the government in Revenue and DM Department, Disaster Management Department, on the following point. 1, if the previous result list communicated by the Board of Secondary Education will be declared void, and the candidates already appointed will be removed from service as their appointment becomes illegal, and fresh appointment order to be issued as per the fresh result list communicated by the Board of Secondary Education. Then 2, whether we may go for fresh recruitment process after cancellation of the previous recruitment process. Then 3, what step will be taken in respect of those employees regarding receipt of their salary. That is Annexure 2 series at page 56. Then 2015, 2 other unsuccessful candidates, namely Anita Mahapatra, respond number 6 in the present appeal, and Subhasis Mahanti, respond number 7, preferred 2 original applications, WPC OAC number so and so of 2015 and WPC 2887 of 2015, praying for similar relief as has been prayed by the respondent of 5, Vijay Kumar. Then 26/2015, the government in the Revenue and DM Department 5 letter dated 26/2015 intimated that candidates who have already joined in the post of junior clerk are to be terminated forthwith. That is Annexure 2 at page 61. Then 2015, challenging the order of the state government dated 26/2015, the present appellant preferred an original application before the State Administrative Tribunal, that is OA number 2221 of 2015, which was subsequently renumbered as WPC OAC number 2221 of 2015, the London Tribunal, while issuing notice in the matter, also passed an interim order not to terminate the service of the present petitioner, and the said interim order was extended from time to time after hearing the parties concerned. Then on 15/1/2019, the respondent number 7, in the meantime, after filing the present writ application, was working as a cooperative inspector under Registered Cooperative Society of Bhubaneswar at Kenzur. He was selected as a cooperative inspector. He has joined there, he is continuing. The respondent number 7 has also qualified in Assistant Section Officer, Group B. He is a higher post also in Odisha Secretariat on 7/6/2019. And he is continuing there. Therefore, the respondent number 7 is not at all interested in the present litigations. Then 7/9/2022, the Honorable Single Judge disposed of the aforesaid writ application along with WPC number 2221 of 2015 and batch, without considering the affidavit filed by the present appellant on 19/9/2021, with a direction to prepare a fresh list in terms of the revised result forwarded by the board. Kindly see Annexure 4 at page 84. My submission is this. If I prepared a short submission supplementing the judgments, there is a judgment. वैसे दे दिया किसने दे दिया तो दिया आगे backward judgment of the so it is paragraph 1. It is humbly submitted that out of total advertised 10 posts initially, 8 candidates joined and subsequently 1 candidate resigned from the post. Now, admittedly, 7 candidates are continuing, including the present appellant.
Just a little. Where is Dr. Lanka? In your case, Dr. Lanka, in your case, those are the individual opposite parties. They are all represented by the council in other writ petitions.
He was also a petitioner in one of the writ applications.
No, that is well, but the other person, that
other 3 persons, in fact, the Vijay Kumar Sahu, Vijay Kumar Parida, he is represented by Mr. Samir Das. He was one of the respondents here. And we found he's the only person who, in fact, if the revised list will be prepared, he's the only person who can.
I am also here. I have intervened. I intervened in the honorable single judge.
But no, I'm concerned about in your appeal, the respondent number 4, Shuchishmita Mahapatra, whether she is represented by any counsel in other litigation.
Lordship, we are in writ appeal number 1255 of 2022, where the appellant.
Madam Pamira is appearing.
And Senior Learned Advocate Mrs. Pamira is appearing.
That is AA number 1255 of 2022.
Oh, she's there already.
Both.
So we can avoid notice, I think.
Yes.
We can avoid notice. We'll start hearing. So ask Miss Roth to come.
She was there.
She's there. She's on her legs.
No, okay, all right. We had started hearing. Okay.
I think her stand also identical to our stand.
All right. Yes.
Yes. It is humbly submitted that out of the total advertised 10 posts initially, and candidate join and subsequently, advertised 10 posts initially, 8 candidates joined and subsequently 1 candidate resigned from the post, and now admittedly 7 candidates are continuing, including the present appellant. And in the meantime, they have already promoted to the post of senior clerk, and one of them have also promoted to the post of head clerk. That is another part. They have continuing for last 9 years those posts. Then 3 candidates, private respondent number 5, 6, and 7, had filed 3 original applications, and out of 3 candidates, one Anita Mahapatra, respondent number 6, could not qualify, for whom Dr. Lenka is appearing, but he says that qualified, you also skip over that. That is what the finding is. One Anita Mahapatra, respondent number 6, could not qualify in the computer-based test, wherein she had secured 2.5 out of 50 marks, that is subject to what my Dr. Lenka will say, which was qualifying in nature. Now, out of 2 remaining candidates, respondent number 7, Subhasis Mahanti, after filing the present writ application, is at present working as a cooperative inspector under Registered Cooperative Society of Bhubaneswar at Kendujhar district. The respondent number 7 has also qualified as Assistant Section Officer, Group B post, on 7/6/2019. Therefore, the respondent number 7 is not, may not be interested, may not be interested. Then 3. Now remaining one candidate, that is respondent number 5, Vijay Kumar Parida, if at all selected in terms of the revised merit list, he can be appointed against one vacant post of UR, which is still vacant. Admittedly, error committed by the opposite party board in the matter of evaluation of answer script could not be attributed to the present appellant, as they have neither been found to have committed any fraud or misrepresentation in their appointment. The appellant have not only completed about now 9 years of continuous service, but they have also been promoted to the higher post as per the recommendation of the DPC. The termination of the present appellant at this stage will not impinge upon his economic security, but also adverse effect. And I am giving two judgments. Two judgment, which Your Lordship kindly look to Your Lordship's order that Your Lordship have referred to. In the order dated REIT appeal number 1259 of 2022, which I am addressing to Your Lordship. 58, yes. 58 of 2022. Your Lordship look to the order number 1 dated 28/9/2022. 28/9/2022. Of a coordinate bench of this honorable court. All counsels had appeared at that time.
Yes.
There are two contentions advanced by the Learned Counsel for the appellant. One is that there are only 2 persons likely to be affected adversely by the impugning order of the Learned Single Judge if the revised select list is published. Secondly, there are sufficient vacancies available against which the said 2 persons can be accommodated. Now I was told that 39 vacancies are there, can be accommodated without affecting the chances of solitary person represented by Mr. Samir Kumar Das, who is likely to qualify as a result of the publication of the revised select list. Reliance is placed on the decision Vikas Pratap Singh, Chhattisgarh, AI 2013 Supreme Court, and Anmol Kumari Tiwari versus State of Jharkhand, AI 2021 Supreme Court, in support of the above contention. It is further point out the affected appellant have worked for more than 8 years, first as junior clerk and thereafter in their promoted post. Issue notice, so and so the revised selection prepared in terms of the impugned judgment of the Learned Single Judge shall be kept in a sealed cover. Now Your Lordship may look to those 2 judgments.
Yes.
I've given to Your Lordship that one is AI 2013 Supreme Court 3414, that Vikas Pratap Singh. Your Lordship may kindly come to paragraph 18. Paragraph 18. I have page mark, running page 5, paragraph 18.
18 of the Monoputra judgment or
Manupatra judgment. Well, I will.
Yes.
Para 18.
Yes.
It is brought to our notice that in view of the interim order passed by the Learned Single Judge by the appellant, single judge, the appellant have now completed their training and have been in service for more than 3 years. Therefore, the only question which survives for consideration and decision is whether, after having undergone training and assumed charge at their places of posting, the 26 appellant be ousted from service on the basis of cancellation of their appointment, qua the revised merit list. Then you also kindly come to paragraph 20. Para 20.
Yes.
If Your Lordship will, I'll take Your Lordship to paragraph 19 also, because another judgment has been cited, para 19 and 20.
Yes.
Sri Rao would submit that the case of the appellant requires sympathetic consideration by this court, since the appointment of the appellant on the basis of a properly conducted competitive examination cannot be said to have been affected by any malpractice or other extraneous consideration or misrepresentation on their part. The ouster of 26 appellants from service after having successfully undergone the training and serving the respondent state for more than 3 years now would cause undue hardship them and ruin their lives and careers. He would further submit that an irretrievable loss in terms of the life and livelihood would be caused to 8 appellants against them who have now become overaged and have also lost the opportunity to appear in the subsequent examinations. He would place reliance upon the decision of this court in Rajesh Kumar versus so-and-so 13-3 scale, wherein this court has directed the state respondent to reevaluate the answer scripts on the basis of the correct model answers key and sympathetically consider the case of the such candidate who, after having been appointed in terms of erroneous evaluation and having served the state for considerable length of time, would not find place in the fresh merit list drawn after evaluation, and directed the respondent state against ousting of such candidates, and further that they be placed at the bottom of the fresh merit list. Para 20. These maxims also, within bracket, fraud and justice never dwell together, has never lost its temper over the centuries, and it continues to dwell in spirit and body of service law jurisprudence. It is law, it is settled law.
This is irrelevant.
Irrelevant. Just come to it is settled law. It is also settled. 1, 2, 3, 4, 5.
Yes.
Yes. It is also settled law that a person appointed erroneously on a post must not reap the benefit of wrongful appointment, jeopardizing the interest of the meritorious and worthy candidates. However, in cases where a wrongful or irregular appointment is made without any mistake on the part of the appointees, and upon discovery of such error or irregularities, the appointee is terminated, this court has taken a sympathetic view in the light of various factors, including the bona fide of the candidate in such appointment and length of service of the candidate after such appointment. Reference has been made to various judgments. Then you also look to paragraph 26 at page 8. In our considered view, in our considered view, the appellant have successfully undergone the training and efficiently serving the respondent state for more than 3 years, and undoubtedly their termination would not only impinge upon the economic security of the appellant and their respondent and their dependent, but also adversely affect their careers. This should be highly unjust and grossly unfair to the appellants, who are innocent appointees of an erroneous evaluation of the answer script. However, their continuance in service should neither give any unfair advantage to the appellant nor cause undue prejudice to the candidate selected qua the revised merit list. Then you respect kind. Accordingly, we direct respondent number state to appoint the appellant in the revised merit list, placing them at the bottom of the said list. The candidate who have crossed the minimum statutory age of the appointment shall be accommodated with the suitable age relaxation. Okay. That is yes, sir. But then kindly come to, sir, the other judgment at page 9, running page 9. That is A 2021 Supreme Court, page 1139. Anmol Kumar Tiwari. You know, sir, kindly come to paragraph 9.
What is the page of the report?
That is, sir, 21 Supreme Court, page 1139.
1139. 39.
Sir.
Name of the parties?
Parties is Anmol Kumari Tiwari and others. Anmol Kumar Tiwari and others versus State of Jharkhand and others. Okay. I think that's it. Kindly come to paragraph 9, sir. In my bunch I have given at running page 12. 9. Internal 4. Yes. 2 issues arise for consideration. The first relates to the correctness of the direction given by the High Court to reinstate the writ petitioner. The High Court directed reinstatement of the writ petitioner after taking into account the fact that they were beneficiaries of the select list that was prepared in an irregular manner. However, the High Court found that the writ petitioner were not responsible for the irregularities committed by the authority in preparation of the select list. Moreover, the writ petitioner were appointed after completion of training and worked for some time. The High Court was of the opinion that writ petitioner ought to be considered for reinstatement without affecting the right of other candidates who are already selected. A similar situation arose in Vikas Pratap Singh, that judgment I cited, where this court considered that the appellants therein were appointed due to an error committed by the respondent in the matter of evaluation of the answer scripts. As there was no allegation of fraud or misrepresentation committed by the appellant therein, the termination of their service was set aside as it would adversely affect their career. That the appellant therein had successfully undergone training and were serving the state for more than 3 years was another reason that was given by this court for setting aside the orders passed by the High Court. As the writ petitioner are similarly situated to the appellant in Vikas Pratap Singh case, we are in agreement with the High Court that the writ petitioner are entitled to the relief granted. Moreover, though on pain of contempt, the writ petition have been reinstated and are working at present. The second issue relates to the claim of the intervener in the writ petition for appointment. There is no doubt the selection to public employment should be on the basis of the merit. Appointment of persons with lesser merit, ignoring those who have secured more marks, would be in violation of Article 14 and 16 of the Constitution. The intervener in the writ application admittedly have secured more marks than the writ petition. After cancellation of the appointment of the writ petitioner, 43% have been appointed from the revised select list. Those 43 persons have secured more marks than the interveners. By the appointment of 43%, the number of posts that were advertised is 384 have been filled up. The intervener have no right for appointment to the post beyond the advertised. The contention on behalf of the intervener in the writ petition is that they cannot be ignored when the relief is granted to the petitioner, writ petitioner, who are less meritorious than them. We are unable to agree. Relief granted to the writ petitioner is mainly on the ground that they have already been appointed and have served the state for some time, and they cannot be punished for no fault of their own. The interveners are not similarly situated to them, and they cannot seek the same relief. The other ground taken by the interveners in the writ application before us is that the relief was denied to them only on the basis of wrong statement made on behalf of the state government that there is no vacancy. No doubt, the interveners have placed on records materials to show that there is no shortage of vacancy for their appointment. One of the reasons given by the High Court for not granting relief to the intervener is lack of vacancy. However, we are not inclined to direct the appointment of the interveners, as selection in the issue pertains to an advertisement issued in 2008. Subsequently, selection to post of sub-inspector have been held and a large number of persons were appointed. The number of posts advertised in 2008 384, and the interveners have no right to an appointment post beyond this advertisement. They cannot claim any parity with the writ petition. They was appointed earlier. Then also kindly come to then the next batch of cases reported in 2018 8 SCC page 81. 2018 8 volume 8 SCC page 81. The name is Richal and others versus Rajasthan Public Service Commission.
Yes. Yes.
Para 26 and 27. Yes. Let's get it.
Yes, read para 26.
Yes, if you also will look to paragraph 26, running page, my page mark is page 24, paragraph 26. In the affidavit filed by the commission, it is mentioned that the result has been revised of only 311 appellants who are before this court. We are of the view that the key answer having been corrected, merit of all candidates except those who have been already selected needs to be redetermined. In our order dated 16/1/2018, it is mentioned that this exercise shall not affect those who have already been selected. We thus are of the view that the commission should revise the entire result of all the candidates except those who have been selected on the basis of the report of the expert committee and publish revised result of all the candidates. When the key answers are correct of the key answers are correct of the candidates who appeared in the examination, they are entitled for revision of their result. Since fault does not lie with the candidate, but lies with the examination body, it shall not equitable to not extend the benefit to those candidates who have not come to the court being satisfied with steps taken by the commission and its earlier expert committee, which was given the task of revising the key answer. Those who have not come to the court, that was it. In our view, paragraph 27, in view of the foregoing discussion, we dispose of this appeal with the following direction. The Rajasthan Public Service Commission is directed to revise the list of all the candidates, including the appellant, on the basis of the report of the expert committee, constituted in pursuance of our order dated 16/1/2018 and published the revised result. 2. While carrying out the above exercise, the commission did not revise the result of all those candidates whose names were included in the select list earlier published. We have already pointed out that the appointment shall not be affected by this exercise. there is no necessity to revise their result. Thus, this exercise shall be undertaken, excluding all candidates who are included in the select list. The commission shall also publish the cut-off mark. We are not concerned. Now you also look to the judgment. Only one, so far as this aspect is concerned, this was, you also look to the brief 1258. नहीं ये देखिए internal page of judgment. Skip the page. You'll also look to paragraph page 101, para 12. Page 101 of the brief of the writ appeal, para 12. Para 12, second paragraph. So far as my contentions raised before the Honorable Single Judge. On the other hand, Mr. Rautrai, his counsel appearing for the private opposite party number 5 and 6 has argued that petitioner has no locus standi to challenge the process of selection, since it is settled law that the candidate who has subjected himself to a particular selection process cannot question it later. That is not important. The next line. Mr. Rautrai further argues that the candidates who are selected and appointed cannot be blamed for the wrong committed by the BSc. Moreover, it is not a case where the petitioner are alleged to have practiced fraud or misrepresented fact to get appointment. Therefore, having been appointed bona fide and having served the government satisfactorily for more than 7 years, the petitioner cannot be thrown out of employment at the belated stage. The further argued, you also skip over.
Yes.
Then the can kindly come to paragraph page 121.
Yes.
If you also will look to page 120, in fact, that starts from para 27, and if you also will look to, sorry, Milord, I'm extremely sorry, that starts from paragraph 26, because in paragraph 26, the judgment which I cited, that has been referred to. So far as this aspect is concerned. That Rajesh Kumar and others versus State of Bihar reported in 13.4 SEC, wherein it was held that while allowing a fresh merit list to be done, the candidate already appointment did not be ousted. Then the finding is paragraph 27. You'll also skip over to page 120, that very same paragraph. If you also will come to the bottom of that page of 120, the Honorable Single Judge, of course, have not considered this aspect, but last 4 lines shall also see. Such is not in a position obtaining in the present case, in as much as only 10 vacancies exist. And in the selection process, only 26 persons had been recommended, out of whom 9 were offered appointment and 7 were appointed. And 7 were appointed ultimately. If the ratio of Rajesh Kumar and others is to be followed in the present case, it would be unworkable, since the event of 7 petitioners are found to be ineligible for appointment, their places have to be taken by the eligible candidate, and there would be no further place for them to be adjusted at the bottom of the list as directed in the case of Rajesh Kumar. The ratio which was decided in that case, which I placed before Lordship, that has not been taken note of. It has been utilized for other purpose, and that has not been given any, the Honorable Single Judge has not given any findings so far that aspect is concerned, so far the ratio of that judgment is concerned. Then and if your ultimate conclusion is paragraph 28 and 29. And in paragraph 29, the order of termination has been quashed. So far as the termination of the present appellant has been quashed, but it has been directed to act on the basis of the revised merit list, and accordingly direction has been made. The impugned order has been set aside. Now at this juncture, I need not, because Madam, my non-friend Mr. Nanda is there. So my humble respectful submission is, I am not going to the merit of the case. Fact remains that we are appointed, we are selected.
You want justice in equity. You should not be ousted. That's your prayer.
That's the point. I
All
did
right.
not. So that is my sum and substance. And one thing I'll make my submission, Madam. So far as Dr. Roth is concerned, he was one of the opposite party before the, he has filed a writ application before the single judge. His entire case is that though the rule provides that the qualifying mark should be this, so he has been disqualified from the very inception. So therefore that is wrong. But my respect to submission, if there are 10 number of vacancy, so far Mr. Samir Das client is concerned, in fact, in the revised list, he comes as an unreserved candidate. And admittedly, there is a vacancy for unreserved candidates. And so far, Dr.
I am for the SCBC, not for unreserved. No, not your grace. By the honorable court, I will get it. Not by your grace. I am a SCBC.
Let the petitioners submit, your lordships. I'll just submit my case. At the threshold, your lordships, I have to admit that this is a very well articulated judgment. Not much I can do. I'll just bring few facts. Fact remains is neither the appellants, neither the private respondents have any play in whatever has been played out. There is no wrongdoing on either of us parts. Admittedly, there were 10 posts offered to 8, 1 left, 7 is there.
Yes.
Of course, I understand there are various more legal positions here also. And admittedly, there were 3 applicants who only claimed for themselves, not in general. And it was an OA, where a little different from the writ court. Normally, the reliefs are limited to the applicants. So, finding the same thing, that only by chance it got transferred here because that body has to be abolished. So, they limited their prayer. One of them is now well placed in the secretariat. So, we have now 2 more people. We still have a surplus of 1. As far as Mr. Das' candidate is concerned, he stood first. So by virtue of his merit, he anyways takes the position in the general category. He will be well absorbed. So it only leaves us with 1 person and we all. That's all the case, your lordships now. And we have worked for 10 years. Possibly will not get a job anyway. So a great deal. And I do understand that we have enjoyed the interim order.
Vacancies.
Lordships?
On the availability of vacancy.
There is 1 surplus, in fact. If we, of course, I also have to tell your lordships that there is a reservation and a roster angle to it also. Mr. Das' client will definitely be adjusted. There is definitely an issue with Mr. Lenka's client because he claims that post which is reserved for women. But he, of course, has a finding against him, and that's why today he's also in appeal. That's all that I will leave it to your lordships. There's not much in law. Much in your lordship's grace and wisdom.
Yes.
Only in addition to what my learned friend submitted, there is a judgment. Even if suppose there is no vacancy in such circumstances, because there is no allegation so far the petitioner are concerned, they are party to fraud or misrepresentations. Even supernumerary post can be created. Here, what has happened? Subsequent to the advertisement, there are vacancies. As on today, 39 vacancies.
No. This is just to it, Mr. Raut, that government has power to create this supernumerary post.
That is what the judgment
judgment are right. But under what circumstances the court can direct them to create supernumerary posts? Not in all circumstances.
All cases, no, I don't say
when
that.
When the illegality is apparent on the face of the records, and the court is taking a decision on that illegality, then of course the court is emboldened to give the direction of the government to create a post. Yes. Usually you do not direct the government to create a post.
Certainly, that is the prerogative of the state.
The government to
that's the prerogative of the state.
Yes.
So your lordship can also pass an order directing in the peculiar fact and circumstances because they have been continuing for last 9 years and they have got the promotion in DPC. They have now, somebody has become an assistant collector. So they are all up.
Regarding the 2%. That someone is joined as an assistant cooperative inspector and other is also. Do you have any information or that is available in any affidavit?
No, I will file an affidavit indicating all those details.
No, regarding those 2 persons, they are saying they don't want to claim any relief anymore.
That is that because they may not come. because we cannot also
Everything
force
now,
them to
now
come to the
everything
court and
depends
file
upon
such
the
claim.
revised merit list.
You are the only person, only authority
can
can say
confirm.
before us that yes, they are already there.
Employed.
And you can also ask them from you whether they have any interest in the going back to the junior clerk position or not. Then in that case, of course, there will two vacancies can be available, only impediment or the embargo will be there regarding the allocation by way of reservation. That will be the another issue.
Sir, there is only one post.
the errors can be there, errors can be corrected by the authority.
Administrative errors. That is the
Administrative errors,
but
it doesn't give any
opportunity
right
has to
any
be
person.
given. No, I'm just saying, my lord, apart from what my learned senior has stated, will not buttress that issue much because that will.
That is the reason Mr. Rautri has not shown us the amendments much. He has shown the judgment. That this is the way the court can also sort out the matter.
Because this is more of a compromise amongst all where everybody can be
that is why
accommodated.
First of all, regarding the availability of the vacancies, we need a statement from the state.
State government. State government would be in the best
Even the
position
new
to.
vacancies are there. We cannot direct against the new vacancies, they can be adjusted. That is another hurdle for the court also.
Whatever vacancy was there on the date of advertisement.
No, that is. date of
Thereafter
the-
also vacancies must have been
date of the
created
selection will take as the deadline for consideration everything. Because selection was found to be erroneous because of applying the wrong answer key. That is the difficulty. So that will be the baseline for consideration. So I think nothing new to be added by the other council. We can keep it parted only waiting for
Yes,
Mr.
that's absolutely.
All will agree.
Kindly see the judgment page, the readable page 84. In my name, find place in the judgment, my lord. And I was intervening in my.
Question is not that. Question is whether you are not the petitioner.
I was intervened, my lord, and my intervention petition was allowed. Kindly see my name.
What is the distinction between an intervener and a party? Tell me.
Right.
The same thing.
Participate in the.
No, the same thing. So you can intervene without being a party, and you can be the party for purpose of intervening
right now
on merit of the proceeding. Is there any distinction?
In constitutional, my name is not there, man.
Intervener's duty that the court take a correct position of law. That's all. He cannot claim any relief from the court. But the relief will naturally flow to him. Of course,
Now I am the beneficiary of the judgment of the honorable single judge.
You are the beneficiary. Yes, nobody is denying it. Nobody is
If
denying you.
if the revised list will be published by the
The entire
government.
effort by the learned council for the appellants are to that make this adjustment in certain nobody
If I will be
suffers.
adjusted.
It is not on law. It is all on equity.
Yes. If I will be adjusted.
Okay. So we keep it as a parter.
Let the state
Mr. Mudali,
government.
how much time do you really require?
Well, it has already been prepared, your lordship. Next month.
No, not.
No, you will
This-
get
This
Vacancy position.
No, he'll also file the merit list, that the revised merit list also. Yes, he'll bring it and file it.
Lordship may call this matter 10 days after.
10 days after, we are today, yes. 18th is okay.
Vacancy position also.
19. 21st? No, 31st is the following. 18th, we keep it on 18th. Because for 19th, this court will be very preoccupied for a special division bench.
2021.
It's through to August 1. It continue up to August 1.
24. Sorry, Saturday.
18th. 18th is all right. Just give the name of all the council. It's appearing various writ appeals. And also for the intervener, find out the names. We just collect the names. Senior council, we all know. But the other council appealing to the interveners, we collect the name, give him. Heard the appellants. But at the request of Mr. P.K. Mudali, an additional government advocate who is appearing for the respondent state, let the matter be listed on 18th July 2023. Meanwhile, the respondent state shall file an affidavit clearly stating that out of the 10 vacancies.
Yes.
Your lordship, you shall also 2 PM if possible, so that.
No, all it will fix at 2 PM.
2 PM.
Out of the 10 vacancies, How many persons have been joined? Stop. And presently, how many vacancies are available against the post of junior clerk? Against the 10 post. In this regard, we like to clarify that the vacancy position be stated as on 19/7/2012. Because there are a lot of vacancies. They have
Subsequently also under different categories might have.
Also 2012. Stop. It has been stated by the learned counsel for the appellants. Then one of these selected candidates had resigned. Stop. Had resigned. Stop. It may also further be pointed out that against the 10 vacancies, 9 candidates were selected, and out of them, 8 candidates joined, and as stated, 1 resigned. As a result, effectively, 7 candidates joined and occupies the post. Stop. These respondent states shall clearly state that whether the 2 candidates as mentioned above have left the post permanently or not, whether they have kept any lien on the post or not. Stop. That apart, the revised merit list as has been prepared in terms of the order dated, what is
2/11/2022.
2/11/2022.
That is passed in writ appeal 1255 of 2022.
255 of 2022. What is the date, Mr. Mudali?
2/11/2022.
November 2020.
Order number 2.
Merit list is prepared in terms of the order dated 2/11/2022. Passed in WPC number 1255.
WA
number 1255 of 2022. Shall be placed before this court for perusal. Stop.
That is for your lordship's perusal. Otherwise, it will, once it's opened, that will create a problem.
Again,
But we have to open it. There's no other alternative.
Your lordships may.
What has happened to that? So far, the first order of Honorable Chief Justice is concerned, that lordship said that whatever decision has been taken pursuant to the order of the single judge, that should be kept in a seal.
In order to clarify the position, I will enclose the select list that will be. I will enclose the select list, revised select list as an annexure so that everybody can verify.
Yes.
Because that is everybody.
There is an issue there.
Issue there.
There is an issue there. Not only whether we get a recovery in merit or not. Some people who have been called for that revised selection. One of them is Mr. Lenka's client. Now, she had participated in the earlier litigation, earlier round of selection. She did not qualify. There is a finding in the single bench. So she should not have at all called. So whether that so-called, calling fresh people and preparing that list, whether it's been correctly done, is itself doubtful. So therefore, I pray your lordship, let's put it for your lordship's perusal only.
In fact, that is what I have passed the order. That I am asked in silk over.
Yes, sir.
Yes.
Precisely
I
the
was
reason.
Apprehending that will create a lot of.
That was precisely the reason why.
But there will be a problem because we will be in a.
Right, otherwise
the entire thing stops interview and
Justice
open the Pandora's box.
So now, my lord, we have learned that the Supreme Court is saying in some cases everything will be fair, no seal cover procedure. You saw it.
Not in all matters. Sorry.
Yes, all right. Now the view is coming up. Now the views are coming up, man.
All right. We'll open it.
So we'll know our
Let them filing first before us. If it is, we find it is very relevant that everybody should No, it will make it open, not that it will keep it. Because the problems will be the appellants.
In fact, after that order was passed by the division bench subsequently, then we have filed an application to recall that order. Of course, we have not pressed that application till date. That is lying.
No, that,
So-
that you cannot do.
That's right. That
You cannot suppress the facts which are relevant.
Yes,
to
your
the
lordship.
context.
Yes, that's for your,
cannot.
for your lordship's co-op. Perusal, we don't have any objection.
Well, first we'll see and.
Right, sir, right, sir, right. I was thinking that.
You want that to be opened.
Yes, but let there be fairness, because I am only appealing for one person. We should know what is our position.
All right.
Because it may so happen, my lord, why I am saying,
All these seven.
they may not come in the way.
We do not know what is there.
Yes, that is why let it be
And let
disclosed
it
so
be
that
first
we.
inspected by us, then if it is relevant to the context, we'll definitely make it
Right,
open.
right.
Oblige, no problem. No issue.
Mr. Muduli shall file such affidavit by the next date. So by the next date, you file.
And you should sort a copy also to us before that.
It is obvious, it is a rule of the High Court.
Yes. So the whole problem is always the state used to file at during the course of hearing.
No, just file.
That is in benefit, that is to the benefit of my learned senior.
But this is a very, very ticklish case.
Yes.
It will be concerning us. Okay, let us see. But really, these people will be nowhere if they are just. You also find out 3 decisions have come. The court can exercise some discretion in equity.
We will try.
No, maybe they have lost the maximum age of getting any employment anywhere. That may be the situation also for some of the candidates. They have already crossed the maximum age.
Age
also.
limit.
And we can always look at that aspect that I just submitted, that, the relief can be confined to people who are there. Especially
before the
because it
court.
was in the
Was
tribunal.
before the court at
Court,
least.
I think that line will get judgment, so.
We'll be getting the opportunity also after this thing, Pandora's box is open.
Yes, that will become more chaotic.
Yes.
Obliged.
Note more sangere college.
49.
Wait, please, ma'am.
File the IA.
Only one copy.
This is the same matter that Rule 333 of that PCP and
Is ready to pay the amount of rupees 2,49,555, my lord. Towards his full and final settlement, my lord.
2 lakh?
2,49,500.
That amount,
Just 500?
249,555.
555.
Okay.
My affidavit is black Z, my lord. Para 2, my lord.
Just a minute, there is some problem in the computer. Just calling. It's not coming. Oh, it's all right. Some corruption. Okay. Yes. You are referring to which?
My lord, flag Z, my affidavit, my lord. Para 2.
You are opposite party number 2.
2, my lord.
Yes. Now, what is your response?
Right now I have received, but my humble submission, can it be raised little more? Because in 2015, in the course of conciliation, they have made this statement. Subsequently, they didn't pay and some. So EPF is, so far the total is concerned, they have said it, that gratuity, compensation and notice pay. To all this, it is amounting to rupees 2,49,555. I leave it to your lordship, can it be raised
They
somehow
will
by
not
that?
pay more than
I'm
that.
ready.
my lord.
So far this.
My instruction is that, my lord, they will not pay more than that, my lord.
No, just to make it some interest, they are entitled to pay. Suppose on that day, you are paying this money, some moderate interest they would earning, but they have lost that. That had to make it 3 lakhs.
I leave it
My
to
lord, I
you.
will take instruction, my lord.
No instruction, is course order. Pay it. It's a rate of interest you are including to that. Don't bargain with that. That is not fair because it is a genuine, because he lost this interest part.
My lord, award is against him, my lord. Award, the labor court award is against him.
I know, that is why the conciliation came back to the conciliation. Otherwise, no purpose of passing that kind of an order that you are responding now. All right. Heard Mr. S.B. Mohanty, Learned Counsel, appearing for the petitioner. By means of this writ petition, the petitioner has asked this court to set aside the Labor Court award dated 29/9/2016, delivered in ID case number 68/2015. Annexure 2 to this writ petition. Stop. It may be notably by the said award dated 29/9/2019, the Labor Court at Bhubaneswar, while dismissing the claim, has observed that even though the opposite party management is covered under the definition of industry, but the writ petitioner, the worker, is not entitled to any compensation as the contractual tenure of the petitioner was over with effect from 1/10/2014. Is it so?
Hello.
Stop. Stop. By the order dated 17/4/2023, we asked the opposite party number to the Chief Executive Voluntary Health Association of India, New Delhi, to make their position clear whether they are inclined to pay the amount they agreed during the conciliation to the petitioner.
In the year 2015.
Mr. S. Das, Learned Counsel, having appeared for the opposite party number 2, has submitted that such affidavit has been filed on 5/5/2023, where they have heard the opposite party number 2 has clearly stated that the amount suggested by the conciliation officer, i.e. rupees 2,49,555, they are ready to pay. For this purpose, we reproduce para 4 from the said affidavit. Para 2. Stop. In compliance with the order of the Honorable Court dated 17/4/2023, where the Honorable Court wants to know whether or not the management is still ready to pay the said amount, I am to submit that opposite party number 1 is ready to pay the said amount of rupees 2,49,555 to the petitioner, which will constitute the full and final settlement of all past and present and future claims, demands, dispute, of whatever nature that existed or may exist between the parties, and upon withdrawal of all litigations filed by the petitioner before various forums, including the labor and EPF authorities, unquote. Mr. Mohanty, learned counsel appealing for the petitioner, has immediately undertook that the petitioner will withdraw if any litigation is pending against the opposite party number 2. On such condition, we direct the opposite party number 2 to pay a total sum of 3 lakhs instead of rupees 1,49,555, is to make good of the value of the original amount that was offered by the conciliation officer and agreed by the opposite party number 2. No further interest would be chargeable. Such amount shall be paid within a period of 6 weeks from today, without fail. So, in terms of the above, this application stands disposed of. A copy of this order be furnished to Mr. Das and Council free of cost.
Except EPF. EPF is the deposit. It's EPF. That is separate, my lord. Because they have deposited, I have also that is a matching share. It is with the authority.
No, this is the all litigations. Litigation, EPF, there is no litigation, I think. We are not forcing you to withdraw your claim, but you cannot continue the litigation. This is a compensation for the termination.
Exactly.
All right.
Exactly.
EPF is a continuous account. If you are working with them or working with some other, it will carry in your name. So there is no dispute in that matter.
Deeply obliged.
25.
Lord, Mr. P.K. Misra, the arguing counsel is held up out of station, my lord. Kindly may
Mr.
it
Misra
come
is appealing for the petitioner?
yes, my lord. Appellant.
Okay, it's appeal.
Not Mr. Samir Kumar Mishra.
Samir Misra is there, but Mr. P.K. Misra is arguing.
It is. You are also there on record?
No.
What is your good name?
Old matter, madam.
Your good name?
S.S. Satyadars.
Mr. S.S. Satyadars, Learned Counsel, appearing on instruction of Mr. P.K. Misra, Learned Counsel, for the appellant, has asked for a short accommodation, as Mr. Misra is presently not available in the state.
P.K. Mishra.
P.K. Misra is presently available in the state. Stop. Let the matter be listed on 2nd of August.
Who's the respondent number 4?
8th of August 2023. Mr. B.K. Mohanty, Learned, Additional Government Advocate, is acting for the respondent.
Private respondent.
Respondent state only, you are appearing?
It says it has been served.
Yes, already. Yes.
The registry reports that notice or something.
Despite notice, none appears for the respondent number 4. Next week.
26.
My lord, on behalf of Mr. Vidyadhar Pradhan, I have appeared in this case. My name is Swagatika Mahapatra. My lord, I pray you to file substitution petition of deceased R4 and 9 and fresh step of R7. 2 is time allowed.
Who expired?
Who expired?
Who are the persons died in the proceeding? Respondents.
4 and 9. See, 4 and 9.
4 and 9.
4 and 9
Ramakrishna and Chintamani.
All right. It has been stated by Ms. S. Mahapatra, Learned Counsel, appealing to the appellant that the respondents number 4 and 5, 4 and 9 have passed away during pendency. Appellant therefore needs substitution of the legal representative of those respondents.
What about 7?
Uh,
She's filed, no, she's filed an IA.
For
Substituting defendant 4 and 9. What about 7?
you have already filed an IA. You have already filed a substitution petition.
No.
Yes.
See the noting. No. Please repeat what you said.
2 is time allowed to file substitution petition.
What substitution petition is there?
In respect of which respondent?
4 and 9.
Only 7.
4 and 9.
9 or 7.
4 and 9 fresh step of respondent number 7. Fresh steps on a dead fresh steps.
Fresh steps for R7.
R7.
And
But we find that you have already filed a substitution petition. That IA number 1898 of 2023.
Let me check whether it is correct or whether they have asked for time to file.
They have already filed it. IA number 180.
That is the noting.
Flag X. You are not properly prepared. You have already filed.
So more time to get the correct take steps for R7.
That is the issue, but we allow this petition.
Yes, ma'am.
This take down IA number 1898 of 2023. Just scroll out the earlier order. There's an application in the order to 20 in application in reference to order 22, rule 4, that is section 51 of the CPC for substitution of respondents number 4 and 9 who passed away in the pendency. Stop. By means of this application, the legal representatives whose particulars has been shown in the schedule have been sought to be substituted in place of those respondents. Mr. D.K. Mohanty, an additional government advocate appearing for the respondent state, did not raise any objection.
So when did they die? They do not there.
No, right.
It
is a writ petition. Stop. Since there is no objection.
Copy is not. Opposite party Indian oil.
What is the necessity of getting the death in the writ proceeding? Since there is no opposition from the state, we allow the appellant to substitute the respondents number 4 and 5.
4 and 9.
4 and 9. In terms of the schedule of the legal representatives. Stop.
Consolidated appeal.
Just consolidated memorandum of appeal shall be filed by incorporating those legal representatives in place of respondents number 4 and 9 by the next date. Let the matter be listed on 31st of July 2023. In terms of above, this application stands disposed of. In the mean rate appeal, appellant is directed to file the consolidated amended memorandum of appeal by the next date. Let this appeal be listed again on 31st July 2023. What about your steps about 7?
My lord, they have to file requisites for the substituted opposite parties.
No,
Again,
let them first incorporate it, then we'll issue notice. What about 7?
Press steps. Sir, press steps for respondent number 7.
How much time?
7 days from now.
2 weeks.
2 weeks. Good.
As the notice sent to respondent number 7 is returned with the postal remarks that in the given address, the respondent number 7 could not be found. The appellant shall take fresh steps for service of notice on the respondent number 7 by the next date. Next.
28. Make me this. Here is the case, my lord. The widow and the other legal heirs of the deceased employee came for pension.
Whether
and
the
pension.
service on the respondent number 4 is complete.
I filed the requisites on 15/2/23. At the back.
Yes. All right.
You're right. Notice sufficient.
Has been completed. Let us fix another date because only received few days back only. So we fixed the matter on the 18th of August.
Melon.
Where the matter will listed on 18/8/2023. It appears from the registry's note that the service on the respondent number 4 is complete. Stop. But there is no representation. It is made absolutely clear if on the next day no representation found from the respondent number 4, no further accommodation will be made, the matter will be heard on merit. Mr. Das, S.K. Das and counsel is appeared for the appellant, whereas Mr. P.K. Moduli, an additional government advocate, has appeared for the opposite of the respondents number 1, 2, and 3.
29.
My lord, so far as the last order may kindly be seen.
22 March.
Yes. Should I place?
In fact, that ordinance, if my lord can take up. So this can be closed. I don't think there is.
That is, yes, that is to be closed. That is only our.
This can be
submission
closed.
also. That has to be closed.
It is yet to be fully implemented, your lordship. I am for the
That-
petitioner, your lordship.
It will be
The
implemented.
rules are yet to come and the competent authority and the appellate authority, they are yet to be appointed. So this honorable court, while
We'll
it's,
observe to according, implement
Yes,
the rules.
Yes.
your timelines may be fixed for that.
8 weeks is, Mr. Mohan, 8 weeks is okay?
My lord, yes, my lord.
8 weeks.
My lord, your lords may kindly appreciate for framing the rules, we have to invite objections from.
That is why I'm providing 8 weeks time.
Your lordship may 3 months, that is required.
All
Your
right.
lordship, 3 months.
3 months.
My lordship, I am appealing for the 14128 WPC.
You have some objection?
That is regarding subplot registration.
This
This
order can be passed.
These are the similar. These
All are similar. Everything depends on.
Judge did not consider my
list tomorrow, 32, 33.
deeply
and
obliged, my
34.
lord.
Item, I beg your pardon, my lord. Item number 44, my lord. It's a case of regulation.
Here
Order
I-
was there, it's a read appeal, my lord. State has preferred and read appeal, my lord. Similarly, similar orders are already been implemented and appreciated by the Honorable Supreme Court, my lord.
Appreciated.
Yes, my lord.
Which one?
Order has also been implemented, my lord.
Which act?
Item number 44, my lord.
What happening, Mr. Kuntia? Is Supreme Court appreciating your action, regularizing?
No, I don't know, but he's some.
Item number 44,
Yes, my-
WOA 200
No,
of 2023.
appreciating the order of the single judge.
Yes, we have,
But you are challenging the order.
perhaps that is not.
Yes, yes. Similar orders are already been upheld by Honorable.
Please give the
Honorable
number so
Supreme
that I can verify.
I'll give.
Without giving the number, he's
So we're
like,
fixing the matter 31st of July.
yes, my lord.
You give the judgment relevant.
Yes, so that I can verify.
Yes,
All right.
yes.
What is your good name?
Atul Tripathi, my lord.
If you have implemented in other cases,
Yes,
then maybe.
Mr. Dev
Five-
Party
five discrimination.
Counsel appearing for the respondents. How many, you are,
There's 7 respondents, my lord.
so respondents is submitted that
On behalf of Mr. B.S.
this writ appeal is covered by a decision of this apex court.
I beg your pardon, my lord.
What is the decision that covers your case?
But there's so many orders, I'll give.
Give
Just
one.
one.
Mention WPC number
Give the
1793.
copy to us.
I'll file, my lord.
One-
I return it right now.
17. But WPC 17 will not be at the Supreme Court. WPC 17.
My lords, I forward.
Perhaps-
17937 of 2020, my lords.
17, similar case.
WPC number
Similar order has been
covered by
Similar, perhaps he's making a wrong
Supan
statement.
Sethi versus state.
Perhaps he's making a wrong
State of-
statement.
Huh?
He's making a wrong statement.
This is a decision regarding Supreme Court dismissed your SLP. Is it
That-
so?
Yes, my lords. Similar order. Well, the
That he's saying similar order.
Yes.
All these are ambulance.
No,
drivers.
this is not. We are wrong because there is a writ appeal judgment.
Yes,
That is the covered by the judgment dated 10 to 2021,
WA 817.
delivered in WA number 817 of 2022, titled as State of Orissa and another versus
WA 817 of
Sushant Shetty.
20.
20.
So the state had challenged that judgment.
10 to
But Apex Court
2021.
has dismissed this state's petition seeking special leave to appeal by the order dated 16/7/2021, delivered in SLP within bracket C numbers 7328 of 2021. So we request Mr. M.K. Kuntil and additional government advocates to examine the said judgment and to inform us whether that covers the present controversy or not.
Yes, ma'am.
By the next date.
My
That the matter will be listed on
31st July, lords.
Huh?
31st July.
30 hours.
Yes. That's one more thing, my lord. There, in this read appeal, there are so many, according to me, my lord, there are nearly 2 years of delay, my lords. But in the petition, they have not mentioned that. So I have also serious objection in so far as delay part is concerned.
All right, you
Yes.
challenge it.
Limitation. Yes.
You challenge it. 2 years delay.
Nearly 2 years delay, my lords.
All right.
2 years delay, got to assume. That COVID period covers and he's
No,
forgetting.
there is a limitation application is there.
But in the petition, they have not mentioned, in the petition, they have not mentioned as to how many days delay it's there.
If COVID covers, then not necessary, but we'll check.
Yes, yes.
WA.
It is not, yes, it is a delay of 677 days. You can note it.
607, yes. I'm grateful, my lords.
677 days delay.
I'm grateful, my lords.
The order was passed on 5/3/2021. So COVID covers till 1/6/2022. If it is 1/6/2022, this case is filed on 10/2/2023 as it appears from my file. So it
No,
covers.
Delay will be coming down.
Yes, madam. That-
No,
that-
delay will be because he has filed within that COVID limitation.
No.
10
Yes,
to
file it after
2020.
that. Limitation, after the cutoff date in the Supreme Court in the convergence is decided, it will be the.
September, I think.
Yes, but till that covers till 1st June
No, that date
2022.
is something in April 2022.
28 to 2022. So that covers 90 days till it covers 1st June 2022.
This will be the explanation. That
Yes,
will not
yes,
be automatic.
sorry, ma'am.
This will
Yes.
not be automatic because
Yes, yes, that,
general
yes,
waiver will not cover.
yes,
it.
ma'am. Yes.
That ground they have not taken in that petition.
Already we'll give that ground to them.
On merit.
I'll get. I'm getting.
Item number 41 may be taken up tomorrow. That is PI.
All right, we'll try to take up tomorrow, yes.
Defects.
Other matters that will be, date will be given.